2024, the Office of the Clerk of the Senate received a response reference number NA/CAN/CO/2024 into brackets 562 and dated 14th of October 2024 to the invitation to appear issued to the National Assembly from the Clerk of the National Assembly indicating that Mrs. G&A Advocates LLP had been appointed to represent the National Assembly and that the National Assembly would appear in person and by advocates. The letter also indicated the members of the National Assembly representing the National Assembly in these proceedings and the witnesses for the National Assembly. Pursuant to Rule 8 of the Rules of Procedure, when considering the proposed removal from office of the Deputy President in plenary, on Monday, 14th of October 2024, the Clerk of the Senate furnished each party with the documentation filed by the other party in accordance with Rule 6 and 7 of the Rules of Procedure. Honorable Senators, ladies and gentlemen, the hearing program, which has been appended to today's order paper, details the various activities in the hearing and determination of the matter and the time allocated for each activity. It will be crucial that all parties comply with the time allocated. I will repeat, it will be crucial that all parties comply with the time allocated. The parties will be notified of the balance of time on each activity through the clerks at the table. In summary, the program states that after we have dispensed with the preliminary matters today, Wednesday, 16th of October 2024, the charges against the Deputy President, as submitted by the National Assembly, shall be read. Thereafter, His Excellency the Deputy President will be given an opportunity to take a plea on the charges. This will be followed by an opening statement by the National Assembly and the Deputy President. After the conclusion of the opening statements, the presentation of the case of the National Assembly shall commence. The National Assembly will have a maximum of 3 hours for presentation of the case and re-examination, while the Deputy President will be allocated 2 hours for cross-examination of witnesses after presentation of the case by the National Assembly. Honorable Senators will be given an opportunity to ask questions or seek clarification from the National Assembly. This should take us up to the end of today's sitting. At the sitting scheduled for tomorrow, Thursday, the 17th of October 2024, His Excellency the Deputy President will present his case before the Senate. The Deputy President will have a maximum of 3 hours for presentation of the case and re-examination, while the National Assembly will be allowed 2 hours for cross-examination of witnesses. Honorable Senators will also be given an opportunity to ask questions or seek clarifications from the Deputy President, following which the closing statements by the parties will be made for a period not exceeding 1 hour each. As provided for under Rule 27 of the Rules of Procedure for removal of Deputy President by impeachment, after the closing statements have been made, the hearing shall conclude and the Senate shall proceed into camera session to deliberate on the issues raised. The Senate shall thereafter proceed to debate a special motion prior to voting on each of the charges. At this stage, a supplementary order paper will be issued to facilitate this debate. In accordance with Article 145(7) of the Constitution and Standing Order 788 of the Senate, the voting shall be by all senators. The Deputy President shall cease to hold office if at least 2/3 of all senators vote to uphold any of the impeachment charges. If, however, the vote in the Senate fails to result in the removal of the Deputy President, the Speaker of the Senate shall notify the Speaker of the National Assembly accordingly. Honorable Senators, I now invite Counsel for the National Assembly to introduce the legal team of the National Assembly and the members representing the National Assembly by stating the full name and designation of each person. You may proceed, Counsel.
Mr. Speaker, sir, for the National Assembly, the legal representation is as follows. The Honorable James Orengo, Senior Counsel, leading the team. Mr. Paul Nyamodi, Legal Counsel. Myself, Eric Gumbo, Legal Counsel. Dr. Mudomi Viankolu, Legal Counsel. Mr. Moses Kipkogei, Legal Counsel. Mr. Peter Wanyama, Legal Counsel, Mr. Ken Meli, Legal Counsel, and Mr. Mwangi Kangu, Legal Counsel. Mr. Speaker, sir, this team is further assisted by a team of our younger colleagues, Mr. Alex Bayer, Legal Counsel, Mr. Elias Ouma, Legal Counsel, Mr. Eric Muriuki, Legal Counsel, Mr. Boniface Mawira, Legal Counsel, and Ms. Joanne Geruto, Legal Counsel. From the National Assembly, we have the Honorable Otiende Amolo, Senior Counsel. We have the Honorable George Gitonga Murugara. We have the Honorable Samuel Chepkonga. We have the Honorable John Makali. And we also have the Honorable Zamzam Mohammed. I submit, Mr. Speaker, sir.
I similarly now invite counsel for His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, to introduce the legal team representing His Excellency the Deputy President by stating the full name and designation of each person. Counsel, you may proceed.
Mheshimiwa Speaker, honorable senators, the legal team representing His Excellency the Deputy President of the Republic of Kenya, who is present in this august house, are as follows. Myself, Paul Muite, Elisha Ongoya, Tom Macharia, Soanya Victor Ogeto, Ndego Wanjiro, John Jomo, Faith Waigwa, Amos Kisilu, George Wandati, George Sakiba, Andrew Muge, Eric Naibei, Mrs. Julia Omwamba, and Mr. Willis Echeza. Mheshimiwa Speaker, we will be raising an issue about one of the members of the legal team read out this morning as representing the National Assembly. I thank you, and I thank honorable members.
Honorable Senators, ladies and gentlemen, on behalf of the Senate, I welcome the National Assembly and its team, His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, and his team, members of the public and the media, to the Senate and to these proceedings. Now, as you're aware, Article 118 of the Constitution mandates Parliament to conduct its business in an open manner, and that its sittings and those of its committees shall be open to the public. The hearing of the proposed removal from office of the Deputy President pursuant to Article 145 of the Constitution, Standing Order 78, and the second schedule to the standing orders of the Senate is a matter that has generated immense public interest. The Senate, in this particular hearing, has facilitated members of the public who are interested in the proceeding to access its galleries. However, I draw the attention of the members of public who are seated in the galleries to Rule 28 of the Speaker's rules, which state as follows. Visitors in the galleries shall remain seated, shall not applaud, comment audibly, make signs, eat, sleep, read books, newspapers, or other material except the order paper for the day, or create any disturbance. I request the members of public to observe the aforesaid rule. Any member of the public who contravenes the Speaker's rule will be inviting stern action against them which includes expulsion from the precincts of Parliament. The office of the Clerk of the Senate is directed to ensure compliance with the Speaker's rules. Honorable Senators, ladies and gentlemen, finally, I now invite the Clerk to read the particulars of the allegations against His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. Clerk, you may proceed.
Mr. Speaker, sir, my name is Degwanjiro, and perhaps before we proceed to the next session, my learned senior counsel, Paul Moite, did raise an issue that we have an objection in terms of the appearances of legal counsel appearing for the National Assembly. Mr. Speaker, sir, our objection is in line with the conduct of this House, and the records bear as witness that we also have, we'll also be relying on an authority in our objection. Mr. Speaker, sir, we are raising an objection to the appearance of my senior advocate, legal counsel, James Orengo, to represent the National Assembly in these proceedings. And this is the basis of our objection briefly, that my learned friend, senior James Orengo, is a full-time serving state officer as per Article 260 of the Constitution, as read together with Section 26, subsection 2 of the Leadership and Integrity Act, which bars a full-time state officer from engaging in meaningful employment. Mr. Speaker, sir, it will be prejudicial to our client if this House was to allow my learned friend, senior James Orengo, to represent the National Assembly in these proceedings. Mr. Speaker, sir, just recently, this House, which is a House of record, we bear as witness that during the impeachment of the Deputy Governor of Kisii County, the County Assembly attempted to appear by legal counsel represented by one Honorable Soro. An objection was raised by my learned friend, Senator Chargay, which objection was sustained by this House. Mr. Speaker, sir, our objection is further premised in the High Court decision, that is High Court Constitutional Petition 204 of 2019, where Justice Ogola barred His Excellency the Governor of Siaya County from representing the then Director General of Kenya Port Authority, one Daniel Maduk. The judgment is before this honorable House that a person who is engaged in full-time employment cannot then purport to appear and represent a party before this assembly. It will raise serious conflict of interests. The same will prejudice our client, and it's also in violation of clear provisions of the law as cited. In that respect, Mr. Speaker, sir, we invite you to uphold our objection before the charges are read out to the to our client. Mr. Speaker, sir, in this ruling that I've just cited, the court was of the view that a person who is engaged in full-time engagement as a state officer cannot and is barred from representing a party in a private capacity. We so beseech you, Mr. Speaker, sir, to uphold our objection. I am most humbled.
Council for the National Assembly, if you look at our program, the preliminary objections were to be raised after His Excellency has taken plea. And therefore, we'll allow the clerk to read the charges. Before anything else, I will allow the Council for the National Assembly to respond, and thereafter I will make my ruling, and then we'll take it from there.
I am most obliged, Mr. Speaker, sir.
Proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. Particulars of the allegations. Your Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, please take the stand. Your Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, the grounds for your proposed removal from office by impeachment, as received by the Senate from the National Assembly, are as follows. Part A, gross violation of the Constitution or any other law pursuant to Article 51(1)(b)(1) of the Constitution. Ground 1, gross violation of Articles 10, 2A, B, and C, 27(4), 73(1)A and 2B, 75(1)C, and 129(2) of the Constitution, and Articles 147(1), as read with Article 131(2)C and D of the Constitution. The preamble of the Constitution provides, among other things, that the people of Kenya adopted and enacted it, A, being proud of the ethnic, cultural, and religious diversity, and a determination to live in peace and unity as one indivisible sovereign nation, and B, recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. The preamble of the Constitution is supplemented by Article 10, 2A, B, and C of the Constitution, which establishes the core national values and principles of governance that bind all state officers, including the Deputy President. These values and principles include patriotism, human dignity, national unity, equity, social justice, inclusiveness, non-discrimination, equality, human rights, protection of the marginalized, democracy, and good governance. Moreover, Articles 73(1)A and 2B of the Constitution establish responsibilities of leadership. They provide that the authority assigned to a state officer, such as the Deputy President, is a public trust to be exercised in a manner that is consistent with the purpose and objects of the Constitution, demonstrates respect for the people, brings honor to the nation and dignity to the office, and promotes public confidence in the integrity of the office. Also, Article 27(4) of the Constitution prohibits all forms of discrimination, including discrimination based on ethnic or social origin, conscience, belief, language, and birth. Further, Article 73(2)B of the Constitution provides that decision-making should be objective and impartial and should not be influenced by favoritism and improper motives. Furthermore, Article 75(1)C of the Constitution provides that a state officer should behave, whether in public and official life, in private life, or in association with other persons, in a manner that avoids demeaning the office he holds. Therefore, as a matter of constitutional compliance, the Deputy President of the Republic of Kenya, who is the principal assistant to the President of the Republic, is required, A, to promote the constitutional core values such as peace and unity of all Kenyans in the context of ethnic, cultural, and religious diversity, patriotism, national unity, rule of law, democracy, and participation of the people, equity, social justice, inclusiveness, equality, human rights, non-discrimination, and protection of the marginalized, and good governance. B, to respect and uphold representation of Kenya's multi-ethnic and culturally diverse society through the promotion of equality and affording equal opportunities to all Kenyans in appointments to the public service and allocation of public resources. And C, to make, promote, and implement public policy decisions that do not discriminate against any Kenyan based on conscience, ethnic or social origin, language, or birth. However, on diverse dates throughout the last 2 years, His Excellency Rigathi Gachagua has persistently made utterances threatening to discriminate, exclude, and unlawfully deny sections of the people of Kenya and regions of the Republic of Kenya equal opportunities for public service appointments and allocation of public resources. Besides, the utterances are highly inflammatory and insightful and significantly undermine national unity and the peaceful coexistence of Kenya's diverse communities. To illustrate, A, sometime in 2023, at a public forum in Kajiado County within the Republic of Kenya, His Excellency Rigathi Gachagua made highly inflammatory and insightful public pronouncements to the effect that the government of Kenya is a company and that the allocation of government development projects and public sector jobs are based on shares determined by how the populace of the various ethnic communities voted in the 2022 general election. Specifically, he stated as follows, quote, "A government is like a company. There is shareholding. Kuna wale who have invested a lot of shares, kuna wale wameweka kidogo, kuna wale wamekataa, lakini wote ni wa Kenya. So ndio tukasema, kama wewe umeenda kupanda mahindi, ama wacha nipeane example ya ng'ombe, kwa sababu niko Kajiado. Wewe uko na ng'ombe yako ya maziwa, hiyo ng'ombe imezaliwa ikiwa njao, umeichunga vizuri, umepatia majani, umenunulia dairy meal, umepatia chumvi, umepeleka kwa malisho, umepatia maji, imezaa, imeanza kukamuliwa. Wewe unatakiwa kwanza ukue mtu ya kwanza kukamua hiyo ng'ombe na kunywa maziwa." End of quote. His Excellency Rigathi Gachagua emphasized the divisive and insightful narrative embodied in the above utterances as follows, quote, "Haiwezekani mtu ambaye alikuwa anakupigia kelele ukichunga hii ng'ombe na kusema hii ng'ombe ni ile ya kienyeji, hakuna haja ya kushughulika naye. Hii ng'ombe ni bure, haiwezi kutoa maziwa. Hii ng'ombe hata ikipona jicho moja, wachana nayo, unapoteza wakati. Saa ile ng'ombe imezaa, imetoa maziwa, amekuja na kikombe, amekuja na sufuria, anataka atolewe maziwa. Mimi nikasema hiyo haiwezekani. Nikasema yule mwenye hii ng'ombe na kuichunga na kuitunza, kwanza akamue maziwa, yeye na watoto wake wakunywe, ile itabaki aitie majirani. Hata yule alikuwa anapiga kelele akisema hii ng'ombe ni bure na haiwezekani, kama kunayo imebaki pia apewe, kama hakuna imebaki atembee. Si namna hiyo?" End of quote. His Excellency Rigathi Gachagua made similar remarks at another public forum as follows, quote, "A government is like a company. I did not say it is a company. I said it is like a company. In every company, There are shares, preferential shares and ordinary shares. When there is an AGM, non-shareholders do not vote or attend the AGM. When there are dividends to be divided, they are divided according to the number of shares. That is the truth. End of quote. His Excellency Rigathi Gachagua continued the insightful and divisive utterances at yet another forum where he stated as follows, quote, sisi lazima tungeangalia nyinyi. Hii serikali ni kampuni na ni ya shares. Si ndio? Ni ya shares. Kuna wenye kampuni, wale wako na shares mingi, wale wako na chache. Kuna wale hawana. Sasa nyinyi mliinvest kwa hii kampuni ya William Ruto na Rigathi Gachagua. Sasa lazima mvune. Yule ambaye alipanda atafanya nini? Simulipanda. Simuliamka mapema. End of quote. At another forum in Nandi County, His Excellency Rigathi Gachagua continued the same divisive and insightful narrative as follows. Quote, Raisa ako pale niko hapo. Raisa ako pale niko hapo. Huyu Felix ako hapo. Mimi mnanijua msimamo wangu ya kwamba watoto wakiwa wengi kuna wale kwanza ya kuangaliwa. Si mnajua? Sasa huyu Felix ako pale ndiye kuunganisha mawaya. Mambo yenu tumepanga. Mambo iko sawa. Chakula iko jikoni, karibu kuiva. Watoto ni wengi, chakula ni kidogo. Iko watoto ya nyumbani, iko wajirani. Iko namna hiyo. Na nyinyi mtulie. Chakula ikiiva, sisi ndio wenye kupakua. Na watoto tunawajua kwa sura na kwa msimamo. Hatuwezi kuwa confused. Kuna mtu hajui watoto wake? Na wiki inakuja tutatangaza hatua kali ile tutachukua na ile maneno tumepanga. End of quote. In addition, in September 2024, during a public rally in Nairobi, His Excellency Rigathi Gachagua made public utterances that incited other communities against the ethnic communities that live around the Mount Kenya region by stating as follows, quote, na mimi mkaniambia nimsaidie rais kwa kazi. Lakini nikiwa hapo kwa serikali, nikuwe pia nikichunga mambo ya watu wa mlima. Niendelee kuchunga mambo ya mlima ama nisichunge? Sasa hiyo kuchunga mambo ya mlima inaniletea matatizo. Ati naambiwa mimi ni mkabila. Mimi ni mkabila kweli? Nikichunga mambo ya watu wa mlima, iko makosa? Iko makosa? End of quote. His Excellency Rigathi Gachagua's utterances throughout the past 2 years undermined the promotion of national unity in the context of Kenyan society's multi-ethnic demography.
Clerk, just pause for a bit. Honorable Senators, just put your phones on silence. Please, proceed, Clerk.
Repeat. His Excellency Rigathi Gachagua's utterances throughout the past 2 years undermined the promotion of national unity in the context of Kenyan society's multi-ethnic demography and multicultural diversity. In addition, they have the potential to alienate, isolate, and create disharmony among the various ethnic communities of Kenya. In summary, His Excellency Rigathi Gachagua's above-mentioned utterances over the last 2 years are impeachable offenses to the extent that they grossly violate Articles 10, 2A, B, and C, 27.4, 73.1A and 2B, 75.1C, and 129.2 of the Constitution, and Article 147.1 as read with Article 131.2C and D of the Constitution. Specifically, His Excellency Rigathi Gachagua's divisive and insightful public utterances over the last 2 years, A, are incompatible with the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, B, can stir ethnic hatred and promote ethnic balkanization of the Republic of Kenya, C, falsely alluded to an non-existent government policy to discriminate and marginalize the populace of the regions and tribes that did not vote for the current administration in the 2022 general elections. Your Excellency, Rigathi Gachagua, how do you plead to ground 1, guilty or not guilty?
Not guilty.
Ground 2, gross violation of Articles 147.1 and 152.1 of the Constitution. Article 147.1 of the Constitution provides that the Deputy President shall be the principal assistant of the President and shall deputize for the President in the execution of the President's functions. In addition, Article 152.1 of the Constitution states that the Deputy President is a member of the Cabinet. On various dates throughout the last 2 years, His Excellency Rigathi Gachagua undermined the President and the Cabinet and the effective discharge of the national government's executive mandate by making unilateral public statements that were inconsistent with policy positions collectively adopted by the government. To illustrate, A, on or around 30th April 2024, the Cabinet passed a resolution for the evacuation of people residing along the Nairobi River. B, shortly after that, His Excellency Rigathi Gachagua made a public statement opposing the Nairobi River riparian evacuation orders, which the Cabinet had sanctioned for public safety and climate change mitigation. His Excellency Rigathi Gachagua made contradictory public statements despite being a member of the Cabinet and being assigned the function of superintending the Nairobi River riparian evacuation order. In addition, His Excellency Rigathi Gachagua has on several occasions throughout the last 2 years made public statements contradicting the President on critical matters of governance and the exercise of the President's functions as a symbol of national unity. To illustrate, in March 2023, at a public forum in the Nyanza region, the President said Kenya belongs to all, notwithstanding how people voted in the 2022 general elections, and that he would ensure the government does not discriminate against anyone. However, His Excellency Rigathi Gachagua, speaking after the President at another public forum, contradicted him by saying that Kenya is a company in which the provision of government services is based on shares. B, His Excellency Rigathi Gachagua has made numerous other utterances at public forums where he publicly restates the divisive narrative that Kenya is a company in which the rights of citizens are based on shares determined by how various ethnic communities voted in the 2022 general elections. His Excellency Rigathi Gachagua's unilateral, divisive, and insightful public statements are impeachable offenses to the extent that A, they undermine the effective discharge of the national government's executive mandate, B, they violate the doctrine of collective responsibility, C, they are equivalent to insubordination of the President, which is incompatible with his constitutional status as the principal assistant to the President of the Republic of Kenya. Your Excellency Rigathi Gachagua, how do you plead to ground 2, guilty or not guilty?
Not guilty.
Ground 3, gross violation of Articles 6.2, 10.2a, 174, 186.1, 189.1, and the 4th schedule to the Constitution, that is, undermining devolution. Article 10.2a of the Constitution provides that devolution is a fundamental national value and principle of governance. In addition, Article 6.2 of the Constitution provides that governments at the county and national levels are distinct and interdependent and shall conduct their mutual relations based on consultation and cooperation. These provisions are supplemented by Article 189(1) of the Constitution, which provides that governments at each level shall perform and exercise their powers in a manner that respects the functional and institutional integrity of government at the other level. Under paragraph 7A of part 2 of the 4th schedule to the Constitution, county governments are responsible for trade development and markets as an exclusive function. Moreover, the Deputy President chairs the Intergovernmental Budget and Economic Council, an essential organ for consultation between the two levels of government. On or around 20th September 2024, His Excellency Rigathi Gachagua, recklessly, unmindful of the high calling and dignified status of the office of the Deputy President of the Republic, unlawfully interfered with the running of Nairobi City County Government by holding a public rally in which he incited citizens against lawful directives of the Nairobi City County Government on the planning and relocation of markets. Further, His Excellency Rigathi Gachagua publicly disparaged the leadership of the Nairobi City County Government and its decisions. Moreover, His Excellency Rigathi Gachagua has interfered with the proper discharge of county government's constitutional functions regarding alcohol control and regulation. His Excellency Rigathi Gachagua's insightful and demeaning public statements and conduct are impeachable offenses to the extent that A, they undermine devolution, B, they undercut the functional and institutional integrity of county governments, C, they unjustifiably vilify and ridicule the leadership of county governments, especially the Nairobi City County Government. Consequently, His Excellency Rigathi Gachagua has grossly violated Articles 6.2.
Clerk, just a minute. I realize what you're reading is fairly long. His Excellency the Deputy President, if you may will, you may sit, and when taking the plea, you may stand.
No, Mr. Speaker, let me stand.
You may proceed, Clerk.
I repeat, consequently, His Excellency Rigathi Gachagua has grossly violated Articles 6.2, 10.2a, 174, 186.1, and 189.1 of the Constitution, as read with the 4th schedule to the Constitution. Your Excellency Rigathi Gachagua, how do you plead to ground 3, guilty or not guilty?
Not guilty.
Ground 4, gross violation of Article 161 of the Constitution, that is, undermining the institutional and decisional independence of judges. Article 161 of the Constitution provides that the judiciary shall be subject only to this Constitution and the law, and shall not be subject to the control or direction of any person or authority. Many international law instruments, treaties, and principles require the guarantee of the judiciary's independence and require all government officers and institutions to respect and observe it. In 2023, His Excellency Rigathi Gachagua, recklessly, unmindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, and the need to respect, protect, and uphold the independence of the judiciary, made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition for the removal of the said judge in gross violation of Article 165 of the Constitution. The Honorable Judge had presided over a case in which His Excellency Rigathi Gachagua was a party and had, in the lawful performance of her judicial function, ordered His Excellency Rigathi Gachagua to forfeit to the state the sum of Kenya shillings 200 million, which she had found to be proceeds of corruption and money laundering. His Excellency Rigathi Gachagua's public attacks against the judge are impeachable offenses to the extent that they undermine the functional and decisional independence of judges. Your Excellency Rigathi Gachagua, how do you plead to ground 4, guilty or not guilty?
Not guilty.
Ground 5, gross violation of Articles 3.1 and 148.5a of the Constitution, that is breach of the oaths of office and allegiance. His Excellency Rigathi Gachagua's actions and utterances outlined in grounds 1, 2, 3, and 4 constitute a gross violation of Article 3(1) of the Constitution, which requires every person to respect, uphold, and defend the Constitution. Further, the actions and utterances of His Excellency Rigathi Gachagua grossly violate Article 148(5)(a) of the Constitution, which prescribes the oath of allegiance of the office of the Deputy President, that obligates the Deputy President to obey, preserve, protect, and defend the Constitution and all other laws. Your Excellency Rigathi Gachagua, how do you plead to ground 5, guilty or not guilty?
Not guilty.
Part B, serious reasons to believe that the Deputy President has committed a crime under national law pursuant to Article 151(b)(2) of the Constitution. Ground 6, serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Section 13 of the National Cohesion and Integration Act provides that it is an offense for any person to use threatening, abusive, or insulting words or behavior where the person intends to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. The section also makes it an offense to use such words or engage in such behavior when, having regard to all the circumstances, ethnic hatred is likely to be stirred up. Besides, Section 62 of the National Cohesion and Integration Act states that a person commits an offense when the person makes statements that are intended or are likely to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. His Excellency Rigathi Gachagua's persistent, inflammatory, reckless, insightful public utterances over the last 2 years, the details of which are set out in grounds 1, 2, 3, and 4, establish serious reasons to believe that he has committed crimes under Section 13(1) and 62 of the National Cohesion and Integration Act. Your Excellency Rigathi Gachagua, how do you plead to ground 6, guilty or not guilty?
Not guilty.
Ground 7, serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Sections 45(1), 46, 47(a)(3), and 48(1) of the Anti-Corruption and Economic Crimes Act, and Sections 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. For the past 2 years, His Excellency Rigathi Gachagua has inexplicably amassed a humongous property portfolio estimated at Kenya shillings 5.2 billion, primarily from proceeds of corruption and money laundering. The value of the property and wealth that His Excellency Rigathi Gachagua has acquired over the last 2 years is incompatible with his non-legitimate income, that is Kenya shillings 12 million per annum or thereabouts. His Excellency Rigathi Gachagua has acquired the above-mentioned property and wealth using his 2 sons, Kevin Rigathi Gachagua, that is Kevin Gachagua, and Keith Ikinu Rigathi, that is Keith Ikinu, and other close family members and associates as proxies. His Excellency Rigathi Gachagua and his proxies, especially the 2 sons, have used the following companies to massively launder money, conceal proceeds of crime, corruption, and benefit from influence peddling. Number 1, Spiritway Limited, PVT-Y2ULDMKY, date of incorporation 14th of September 2023, shareholders Dorcas Wanjiko Rigathi, who is director, stroke shareholder, stroke beneficial owner with 100 shares. 2, Fortis Viz Group Limited, PVT-MKUMAKEE, date of incorporation 14th of February 2023, Shareholders Kevin Rigathi Gachagua with 50 shares and Keith Ikinu Rigathi 50 shares. 3. Grand Bypass Apartments Limited, PVT-5JUZEKL8, date of incorporation 11th of January 2024. Shareholders Rigathi Gachagua, Director, John Mwai Madenge of 7676931 as Director, Peter Njoroge Regeru, number 4686103, Director, Vipingo Beach Resort Limited, number C159289, shareholder with 1 share. 4. Kuruwitu Properties Limited, PVT-EYUBKG83, date of incorporation 26th of April 2023. Shareholders Vipingo Beach Resort Limited, number C159289, as shareholder with 1,000 shares, and John Mwai Madenge. Number 5, the Anansi Collective, BN-JRCG76AG, date of incorporation 29th of March 2021. Shareholders Keith Ikinu Rigathi. 7. Calvary Creed International Limited, number CPR/2015/186154, date of incorporation 16th of April 2015. Shareholders Rigathi Gachagua with 50 shares, Dorcas Wanjiko Rigathi 950 shares. 8. Cosmia Venture Limited, number PVT-Q7ULE6Z, date of incorporation 26th of February 2018. Shareholders Herman Zoita Maina 200 shares, James Mwangi Kagodho 50 shares, Kevin Rigathi Gachagua 250 shares, Keith Ikinu Rigathi 50 shares, Irene Nyanjao Washira 250 shares, and David Kipkemboi Mudhamia 200 shares. Number 9, Cristo Kenya Limited, number CPR/2009/4898, date of incorporation 12th of June 2009. Shareholders Kevin Rigathi Gachagua 200 shares, Keith Ikinu Rigathi 200 shares. 10. Delta Merchants Limited, number CPR/2009/4874, date of incorporation 9th of June 2009. Shareholders Rigathi Gachagua 200 shares, Dorcas Wanjiko Rigathi 200 shares. 11. Vipingo Beach Resort Limited, number C159289, date of incorporation 5th of August 2008. Shareholders Kevin Rigathi Gachagua as Director, Keith Ikinu Rigathi, Director, estate of the deceased James Nderito Gachagua, shareholder with 10,000 shares. 12. Rigathi Gachagua Foundation, number CLG-XXFXRG, date of incorporation 11th of November 2022. Shareholders Rigathi Gachagua. 13. Dorcas Rigathi Foundation, number CLG-G9FV2G, date of incorporation 19th of October 2022. Shareholders Kevin Rigathi Gachagua, Keith Ikinu Rigathi, Dorcas Wanjiko Rigathi, Nancy Wamboi Kang'ethe. 14. Heartland Supplies Limited, number CPR/2009/4881, date of incorporation 11th of June 2009. Shareholders Rigathi Gachagua, director stock shareholder with 200 shares. Dorcas Wanjiko Rigathi as director and shareholder with 200 shares. 15, Karandi Farm Limited, number C94303, date of incorporation 25th of June 2001. Shareholders Rigathi Gachagua as director, shareholder with 700 shares. Dorcas Wanjiko Rigathi as director and shareholder with 100 shares. 16, Morani Manufacturers Limited, number PVT-8LU7Q8GD, date of incorporation 13th of October 2021. Shareholders Dorcas Wanjiko Rigathi as director and shareholder, 200 shares. Keith Ikinu Rigathi, director and shareholder, 200 shares. Joshua Karianjahi Waiganjo, director, shareholder, 600 shares. And Grace Washuka Mwangi, beneficial owner. 17, Mothers of the Land Limited, number CLG-55FD3B, date of incorporation 1st of December 2021. Shareholders Louisa Njeri Wanjiro, director stroke member. Caroline Jepkemboi Waiyaki, director stroke member. Lucy Njogoine Mutegi, director stroke member. Dorcas Wanjiko Rigathi, director stroke member. 18, Pioneer Medical Kenya Limited, number CPR stroke 2009 stroke 4910, date of incorporation 9th of June 2009. Shareholders Rigathi Gachagua as director stroke shareholder, 200 shares. Dorcas Wanjiko Rigathi, director and shareholder, 200 shares. 19, Ryder Furniture Mart Limited, number C141876, date of incorporation 18th of July 2007. Shareholders Rigathi Gachagua as director and shareholder, 500 shares. Dorcas Wanjiko Rigathi as director and shareholder, 500 shares. 20, Royal Crimson Ventures Limited, number PVT-LRU2QZL, date of incorporation 26th of February 2018. Shareholders Kevin Rigathi Gachagua as director and shareholder with 400 shares. Keith Ikinu Rigathi as director and shareholder, 400 shares. And Peter Kangagi Githaiga as director and shareholder, 200 shares. 21, Technical Supplies and Services Limited, Kenya Limited, date of incorporation 6th of June 2009. Shareholders Rigathi Gachagua as director, stock shareholder with 400 shares. Sorry, I said that again. 21, Technical Supplies and Services Kenya Limited, CPR 2009/4895. Date of incorporation is 6th of June 2009. Shareholders are Rigathi Gachagua, director, stock shareholder with 400 shares, and Francis Moshiri Wanguo, director. And 22, Wamunyoro Investments Limited, number C93670, date of incorporation 23rd of April 2001. Shareholders Kevin Rigathi Gachagua as director, stock shareholder with 1 share, and Keith Ikinu Rigathi, director, stock shareholder with 1 share. To illustrate, in November 2023, Crystal Kenya Limited, number 9 in the above table, a proxy company of His Excellency Rigathi Gachagua, purchased Outspan Hotel, situated at Nyeri Municipality Block /1669 from Aberdare Safari Hotels for Kenya shillings 535 million. The directors of Cristo Kenya Limited are the sons of His Excellency Rigathi Gachagua, namely Kevin Gachagua and Keith Ikinu. Sometime in August 2024, His Excellency Rigathi Gachagua publicly admitted that his family had acquired this property. B. In November 2023, Kevin Gachagua and Keith Ikinu, the proxies of His Excellency Rigathi Gachagua, acquired Treetops Lodge, a high-end hotel situated in Nyeri County. Sometime in August 2024, His Excellency Rigathi Gachagua publicly admitted that his family had acquired this property. C. His Excellency Rigathi Gachagua and his proxies also acquired Olive Gardens Hotel and Queen's Gate Serviced Apartments in Nairobi. D. His Excellency Rigathi Gachagua acquired Vipingo Beach Resort in Kilifi County. E. His Excellency Rigathi Gachagua acquired a parcel of land known as Rogoro Kiamariga 1223 in Madera East constituency, where he constructed a helicopter landing facility. F. His Excellency Rigathi Gachagua acquired approximately 40 acres of land in Kakuret in Kamburaine in Nyeri County. G. His Excellency Rigathi Gachagua acquired 80 acres of land in Meru County. H. His Excellency Rigathi Gachagua acquired a dairy farm in Nyandarua County. I. Additionally, His Excellency Rigathi Gachagua used his office of Deputy President to exert influence and connive with unscrupulous Ministry of Lands officials to issue an allotment letter to Amunyoro Investments Limited, a company that he owns, to acquire LR 209/12077 and LR 90923, situated at Embakasi in Nairobi, whose value is estimated at Kenya shillings 1.5 billion or thereabouts. After that, this company used the fraudulently acquired documents to support a court case at the expense of the legitimate owner of the property. J. Moreover, companies associated with His Excellency Rigathi Gachagua and his proxies were involved in the KEMSA Kenya shillings 3.7 billion irregular procurement of malaria nets that put the lives of millions of Kenyans at risk. K. In addition, His Excellency Rigathi Gachagua has used the office of Deputy President to corruptly influence unnecessary and expensive renovation of his official residence in Karen and Mombasa, running into millions of shillings. In essence, His Excellency Rigathi Gachagua has chosen personal comfort, extreme luxury, and pomposity at the expense of service delivery to the people of Kenya. L. Images of some of the properties that His Excellency Rigathi Gachagua has acquired from proceeds of corruption, influence peddling, and money laundering have been provided and relate to the following. 1. Treetops Hotel, located in Nyeri. 2. Outspan Hotel, located in Aberdare Ranges. 3. Olive Gardens Hotel, Agwings Kodhek Road. And 4. Vipingo Beach Resort. Additionally, His Excellency Rigathi Gachagua has the following proxy companies to trade with the office he holds. A. Agrobrick Investments Limited. It is a private limited company incorporated in Kenya on 28th May 2017 under certificate number PVT-RXUP6E. The company deals in building and construction. The company's directors / shareholders are A. Rudani Mayur Kumar Mahendrabai, and B. Patel Ankit Kumar Hasmukbai, an Kenyan national. 48. The company operates a bank account, number withheld for data protection reasons, at Sidian Bank, opened on 19th February 2022, with the company directors as the account signatories. On 18th October 2022, Bhavika Nathalal Hirani was added as an account signatory and given the full mandate to operate the account. Bhavika Nathalal Hirani is a proxy of His Excellency Rigathi Gachagua. On 23rd January 2023, the company account received a transfer of Kenya shillings 47,015,367 shillings and 75 cents from the Executive Office of the Deputy President. The payment was supported by a notification of award letter, reference number ODP stroke ADM ADM.1 stroke 57 VO.4 bracket 70 dated 16th December 2022 from the Office of the Deputy President to Agrobrick Investment Limited for the proposed refurbishment of Deputy President's official residence at Karen at a cost of Kenya shillings 55,559,520. B. Payment voucher of Kenya shillings 55,133,265.92 was received on 10th January 2023 as the first interim payment in respect of the contract ODP-RT-001, ODP-RT-001/2022-2023. C. An agreement letter dated 22nd December 2022 between Office of Deputy President and Agrobrick Investment Limited for the proposed renovation of Deputy President's official residence in Karen. Bhavika Nathalal Hirani signed the document as a director of Agrobrick Investment Limited. On 23rd January 2023, the funds were suspiciously transferred through a transfer of Kenya shillings 45 million to a related entity, that is, Vaggiani Enterprises Limited. Shockingly, the account had been dormant for around 9 months before it received the payment from the Office of the Deputy President, adding to the reasonable suspicion that it was a special purpose vehicle to siphon funds for His Excellency Rigathi Gachagua. B. Lusona Events Limited. This is an events management company that was registered on 30th of October 2012 under certificate number CPR/2012/87037. The company directors are A. Esther Wanjiro Njenga and B. Cecilia Mudhoni Njenga. The company operates 2 accounts at the SBM Bank, which it opened in 2015. The company's directors are account signatories. Ian Njuguna Gitata was also introduced as an account signatory and is the sole account operator, pointing to the likelihood that he is the beneficial owner. Between 1st January 2024 and 11th July 2024, the account at SBM Bank received a total of 100 million shillings, 262,821.43 cents from the Office of the Deputy President, characterized by the receipt of multiple transfers. On 2nd of July 2024, the Deputy President's Office paid Lusona Events Limited part of the above-mentioned proceeds of corruption and money laundering in 8 transactions in a single day as follows. On 2nd of July 2024, the amount of 2,946,900. Secondly, on 2nd of July 2024, the amount of 4,806,639 shillings. Thirdly, on 2nd of July 2024, the amount of 4,679,130 shillings. Fourthly, on 2nd of July 2024, the amount of 2,955,450 shillings. Fifth, on 2nd of July 2024, the amount of 3,374,400 shillings. Sixthly, on 2nd of July 2024, the amount of 5,451,912 shillings and 40 cents. Number 7, on 2nd of July 2024, the amount of 3,582,536 shillings and 50 cents. And number 8, on 2nd of July 2024, the amount of 3,840,625 shillings and 60 cents. A substantial portion of the Kenya shillings 100,262,821 and 43 cents was used for luxurious largesse and unnecessary expenditure for carpets, etc., laid down for the Deputy President's functions. Some of the funds were utilized as follows. A. Ian Gitata made Kenya shillings 22,800,000 in cash withdrawals. Some of the withdrawals were declared as cash to pay undisclosed beneficiaries. It was suspicious why they preferred cash payments as opposed to bank transfers. B. Kenya shillings 4 million transferred to a law firm. C. Kenya shillings 26,993,350 investment in fixed term deposits as follows. 1. On 27th of May 2024, Kenya shillings 9,993,350. 2. On 11th July 2024, Kenya shillings 17 million. The utilization of funds was reasonably believed to be an act of corruption and money laundering, as most of the money was withdrawn in cash rather than bank transfers, which is a custom for huge payments. His Excellency Rigathi Gachagua is reasonably suspected to be the principal beneficiary of these dubious transactions. C. St. Nicholas Rehabilitation and Industrial Training Institute Limited. The company was incorporated on 8th of April 2021 under registration number PVT-AAACMO4. It deals with student rehabilitation and industrial training, trading as St. Nicholas Rehabilitation Center and Psychiatric Hospital. The sole company director is Nicholas Mugambi Maingi. The company operates an account at Equity Bank, opened on 18th August 2017, with the company director as the sole account signatory. Between 1st March 2024 and 5th June 2024, the account received a total of Kenya shillings 21,060,000 from the office of the Deputy President. The funds were suspiciously utilized as follows. A. Kenya shillings 2 million was allegedly used to purchase a white Toyota Prado from Umarali Motors Limited for Kenya shillings 8.5 million. B. Another Kenya shillings 4 million was suspiciously transferred to Nicholas Maingi's account. A cash trail in the personal account revealed that upon receipt of the funds, Nicholas made a transfer of Kenya shillings 4,660,000 to Umarali Motors Limited on 21st March 2024. The purported payment to Umarali Motors Limited using two routes raises reasonable suspicion of corruption and money laundering. Further, prior to receipt of the two payments from the Office of the Deputy President, the account was transacting in minimal accounts, raising suspicions that the entire transaction was a conduit used by His Excellency Rigathi Gachagua to siphon public funds. The payment scheme used typifies money laundering transactions. From the matters outlined in the preceding parts, it is patently clear that there are serious reasons to believe that His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, using his state office, has committed gross economic crimes, namely conflict of interest, abuse of office, conspiracy to commit crimes under A, sections 45(1)(a), 46, 47(a)(3), and 48(1) of the Anti-Corruption and Economic Crimes Act, and B, sections 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. Your Excellency, Rigathi Gachagua, how do you plead to count 7, guilty or not guilty?
Not guilty.
Ground 8, serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. His Excellency Rigathi Gachagua has continuously misled members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. To illustrate, sometime in January 2024, His Excellency Rigathi Gachagua made a sensational but false accusation that Honorable Justice Esther Maina, Judge of the High Court of Kenya, had engaged in corruption. He publicly said he would present a petition for the removal of the said judge, which he has not done to date, leading to the inevitable conclusion that he knew his allegations were false. On or about 26th of June 2024, His Excellency Rigathi Gachagua, recklessly and unmindful of the high calling and dignified status of the Office of the Deputy President of the Republic and his membership to the National Security Council, both being positions that require one to be a discreet and tempered leader, especially during moments of national crisis, addressed Kenyans on live television in Mombasa County and publicly made sensational statements against the National Intelligence Service, an essential national security organ, its director, and officers. The following is an excerpt of part of his speech. I quote, "The Director General of the National Intelligence Service, Nurdin Haji, was a junior officer in the National Intelligence Service before he was appointed as DPP. When he was appointed to the office of the Director General, because of his inferiority complex, he chased away all the people who were senior to him when he was in the service, therefore crippling the capacity of that service and making it dysfunctional. 3 directors were chased away and reassigned to desk jobs in ministries across government. 13 assistant directors, men and women with proven track record of intelligence collection and analysis, were removed from the National Intelligence Service, leaving a shell and a clueless Director General who has no capacity to run the organization. And that is why the security sector was caught off guard by the intensity, the anger of the Kenyan people, the agitation of the Kenyan people, the resilience of the Kenyan people." End of quote. Your Excellency Rigathi Gachagua, how do you plead to ground 8, guilty or not guilty?
Not guilty.
Part C, gross misconduct pursuant to Article 151(b)(3) of the Constitution. Ground 9, gross misconduct, that is public attacks on National Security Intelligence Service and its officers. The phrase gross misconduct generally refers to behavior that is, quote, very unpleasant, disgusting, or very rude. This is from the Oxford Advanced Learners Dictionary. Therefore, public attacks against an essential national security organ in circumstances that require one to be discreet and tempered constitute gross misconduct. On or around 26th of June 2024, His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, unmindful of the high calling and dignified status of the Office of the Deputy President of the Republic of Kenya and his membership to the National Security Council, both being positions that require a leader to be discreet and tempered, especially during moments of national crisis, addressed Kenyans on live television in Mombasa County and made a scathing attack on the National Intelligence Service, an essential national security organ. His Excellency Rigathi Gachagua extended the extremely reckless personal attacks to the Director General of the institution. With the unprecedented acts, His Excellency Rigathi Gachagua acted in a manner that is incompatible with the high calling and dignified status of the office of the Deputy President and member of the Cabinet and the National Security Council. The attacks against the National Intelligence Service and its Director General constitute gross misconduct and an impeachable offense to the extent that A, they are incompatible with the high calling and dignified status of the office of the Deputy President of the Republic of Kenya. B, they undermine national security from both internal and external points of view. C, they are incompatible with the effective discharge of the delicate and sensitive mandate of the National Intelligence Service. D, they had the potential, given the circumstances prevailing in the country at the time, to significantly diminish public confidence in the viability of the Kenyan state and its ability to protect the lives and properties of its citizens. E, they go against the constitutionally prescribed oath of allegiance of the office of the Deputy President under Article 148, 5A of the Constitution, which requires the Deputy President to obey, preserve, protect, and defend the Constitution and all other laws. Your Excellency, Rigathi Gachagua, how do you plead to ground 9, guilty or not guilty?
Not guilty.
Ground 10, gross misconduct, that is insubordination. As stated in ground 9, the phrase gross misconduct generally refers to behavior that is very unpleasant, disgusting, very rude. This is from the Oxford Advanced Learners Dictionary. Therefore, open or public insubordination of the President, who is the head of state and government under our constitutional framework, is gross misconduct. As stated in the preceding parts, Article 147(1) of the Constitution designates the Deputy President as the principal assistant of the President, who shall deputize for the President in the execution of the President's functions. His Excellency Rigathi Gachagua has persistently undermined, demeaned, and committed insubordination instead of assisting the President in executing the state executive mandate. Instead, he has opted to run a smear campaign against the Presidency for political expediency. Further, whereas Article 147(2) of the Constitution requires the Deputy President to perform the functions conferred by the Constitution and any other functions that the President may assign, His Excellency Rigathi Gachagua is openly sabotaging the state's efforts in agriculture, including the coffee, tea, sugar, and milk sectors, which the President tasked him to oversee. To illustrate, A, His Excellency Rigathi Gachagua has connived with cartels in the tea sector to block the Kenya Tea Development Agency from implementing guaranteed minimum returns that would benefit smallholder tea farmers. B, His Excellency Rigathi Gachagua has influenced his family members, allies, associates, and proxies to take control of a local cooperative society, name withheld in Madeira, which they are financially hemorrhaging. Your Excellency Rigathi Gachagua, how do you plead to ground 10, guilty or not guilty?
Not guilty.
Ground 11, gross misconduct, that is bullying. As stated in ground 9, the phrase gross misconduct generally refers to behavior that is very unpleasant, disgusting, or very rude. This is from the Oxford Advanced Learners Dictionary. Section 34 of the Leadership and Integrity Act provides that a state officer shall not bully any person. Bullying includes repeated offensive behavior that is vindictive, cruel, malicious, or humiliating, and is intended to undermine a person. For the past 2 years, His Excellency Rigathi Gachagua has persistently bullied state and public officers. To illustrate, A, His Excellency Rigathi Gachagua bullied Kenya Medical Supplies Agency officials into awarding a tender for the supply of mosquito nets to Crystal Limited, his proxy company. Crystal Limited has submitted a fake bid bond with the sole intention of fraudulently acquiring public property. B, His Excellency Rigathi Gachagua routinely bullies public officers in national security organs whom he subjects to public attacks and humiliation. C, His Excellency Rigathi Gachagua routinely summons procurement officers in ministries and state institutions and instructs them to direct the procurement of goods and services in a particular manner. D, in the presidency, His Excellency Rigathi Gachagua identified public officers who he thinks stand in his way of creating dominance within government and political kingship, and he has severely threatened, intimidated, and harassed them. E, in 2023, His Excellency Rigathi Gachagua used his position as a deputy president to intimidate public officers and a contractor to divert materials meant for the construction of the Kilifi-Malindi Road to tarmac. Your Excellency Rigathi Gachagua, how do you plead to ground 11? Guilty or not guilty?
Not guilty.
His Excellency the Deputy President, you may take your seat. Counsel for the National Assembly, you may proceed to respond to the objection that has been raised by Counsel for the Deputy President.
Perhaps, Mr. Speaker, sir, just before Council responds to my application, for efficiency and expediency, permit me also to bring to the attention one more application in respect to the documents that were served upon the Deputy President. Mr. Speaker, sir, by a letter that you referred to, sent from the Speaker of the National Assembly to the Speaker of the Senate, the Speaker of the National Assembly did submit the documents that emanated from the National Assembly.
Counsel for the Deputy President, take your seat first. You'll have your moment.
Mr. Speaker, sir, if I could take a few moments this afternoon to respond to the preliminary objection that has been raised. I have three quick issues in response to that objection. Number one, the Constitution of Kenya at Article 77 is the primary law that then speaks to restrictions on activities of state officers. In particular, Article 77(1) reads, "A full-time state officer shall not participate in any other gainful employment." Mr. Speaker, sir, that article introduces one critical variable: gainful employment. Mr. Speaker, sir, gainful employment has been defined within our laws. Specifically, Section 26 of the Leadership and Integrity Act has defined what would amount to gainful employment. If I may, Mr. Speaker, sir, Section 26(1) reads, "Subject to subsection 2, a state officer who is serving on a full-time basis shall not participate in any other gainful employment." It then proceeds at subsection 2 to say, in this section, gainful employment means work that a person can pursue and perform for money or other form of compensation or remuneration which is inherently incompatible with the responsibilities of the state office or which results in the impairment of a judgment of a state officer in the execution of the functions of a state office, or results in a conflict of interest in terms of Section 16. And so to our response, there has been no assertion that learned senior counsel James Orengo, by representing a party before this House, has participated in gainful employment. In any case, what evidence has been tendered before this Honorable House to speak to that fact? Mr. Speaker, sir, that is a question that has also received judicial interpretation. If I may, in the election petition number 3 of 2013 filed in the High Court in Busia, a similar application was made, again objecting to the participation of the Honorable James Orengo Senior Counsel in the proceedings in that matter. The judge handling that case interpreted both Article 77 as read with Section 26 of the Leadership and Integrity Act, and had this to say, at paragraph 28, that it had been argued that by representing a party in an election petition, the Honorable Senator would be compromising the political neutrality of his office. I would not agree. Section 23 of this Act is a provision on political neutrality expected of appointed state officers. Honorable Orengo holds an elective position. Elected members of Senate are politicians. The provisions of Section 23 do not apply to them. So even if it was to be assumed that, that by representing the third respondent, Honorable Orengo is pursuing a political agenda, that would not be inimical to his office as a member of the Senate. And so, Mr. Speaker, I submit that unless there is material that will be tabled before this House, that by appearing for a party before this House, then the Honorable Mr. James Orengo Senior Counsel would have engaged in gainful employment. That objection does not stand any merit. Number two, the second test that has been applied by courts is the test around conflict of interest. Again, Mr. Speaker, our courts have had occasion to interpret what amounts to conflict of interest. In a case determined by a 5-judge bench, a case reported in our laws, that is EKLR 2018, the case of Philomena Mbete Mwilu versus the DPP and two others, the bench, in determining and dismissing a similar application, defined conflict of interest as a situation where one is confronted by two different interests, so that serving one interest would be against the other. Mr. Speaker, sir, there hasn't been any conflict of interest that has been, even in the least, mentioned by the objector to the participation of Senior Counsel, the Honorable James Orengo. Finally, has there been an indication as to any prejudice that could be occasioned by the participation of the Honorable James Orengo Senior Counsel before this House this afternoon? To the best of my recollection, none has been mentioned. Is counsel, for instance, saying that the party presented, then as advocates, as counsel, we operate within very clear and defined rules. Those rules are meant to ensure that a party before this House, just like would be a party before any court or any other forum, does not suffer or does not have a compromise to their rights to fair hearing under Article 50. In the absence of any prejudice that has been mentioned before you, we urge that that objection be dismissed. I've also had occasion to look at the case that was referred to by my learned friend, Mr. Njiru, and with respect, that case turned on two critical points. The first one being that the participation of the Honorable James Orengo as a senator in that matter was said to have had the potential of compromising his participation or departure between what led to the finding in that decision and what we have before you. The judge in that specific matter also went on to add that there must also be established a question or a fact of benefit. Again, I reiterate that no indication, no evidence, or even assertion has been presented before this House to suggest that the Honorable James Orengo Senior Counsel has in any way benefited by being in this House participating as counsel. So with that, Mr. Speaker, sir, we urge that that objection be dismissed. I am most obliged.
Thank you, Counsel, for His Excellency the Deputy President.
Thank you, Mr. Speaker, sir. And in brief response to the submissions by my learned friend, there is no denial that has come from Counsel's defense that Senior Counsel Honorable James Orengo is here on pro bono basis. That evidence has not been brought. That claim has not been denied. He's therefore here as counsel earning a fee, and that is what Section 26.
Senior Counsel, don't go to that line of argument. If the evidence of him acting pro bono has not been laid on the table, has the evidence of him earning been put on the table?
Mr. Speaker, sir, the only presumption...
No, we are not going to presume facts. We are not.
Mr. Speaker, sir, I am well guided, but it may be noted and may go on record that the grounds laid by Section 26, subsection 2, have not been rebutted by the submissions made by counsel insofar as the gainful employment in these proceedings is concerned. Number two, he is here as a governor of Siaya County, not as a senator. And as such, the petition number 3 of 2013 is distinguishable from the fact that he's here as a serving governor. And that is what Section 26, subsection 2 speaks to, and that is also equally the provisions of Article 77 of the Constitution. Further to that, Mr. Speaker, sir, the test of prejudice is a creation by counsel. It is not the one that at Section 26, subsection 2, and Article 77 speaks to. The only test is gainful employment. Unless that one is rebutted, the general presumption, again, Your Lordship and Mr. Speaker, sir, and that is a legal presumption, unless it is rebutted, is that he is here for a main purpose to earn a living. Mr. Speaker, sir, I leave that to the House to make a determination. Permit me once more to move the House with my last and final application. Yeah, insofar as, Mr. Speaker, sir, these proceedings are in issue. Mr. Speaker, sir, on the 8th of October, 2024, this House was served with a resolution from the National Assembly by the Speaker of the National Assembly, via the letter that the Speaker of the Senate referred to. That letter, Mr. Speaker, sir, appears at page 547 to 548 of volume 5 of the National Assembly's bundle of documents. There is no, Mr. Speaker, sir, we were then served with 2 sets of documents, an affidavit dated the 11th of October, deponed by one Peterson Jomo Mushira. Our objection, Mr. Speaker, sir, is that that document, that affidavit, did not form part of the documents that were submitted by the Speaker of the National Assembly to the Speaker of the Senate. It's our argument, Mr. Speaker, sir, that this is new evidence. Further to that, Mr. Speaker, sir, we were equally served with a bundle of documents from the National Assembly, which is labeled as Volume 8A, which is also indicated as responses from various government agencies. Again, Mr. Speaker, sir, this is new evidence that does not find itself at page 547 to 548 of the bundle of documents submitted to you or to this Honorable House by the Speaker. The prejudice, Mr. Speaker, sir, is that our response was exclusively limited to the documents that we were served with. Further to that, Mr. Speaker, sir, it's our argument and our application that these documents will prejudice our case in the sense that, Mr. Speaker, sir, they will violate our rights to a fair hearing. This is trial by ambush by the National Assembly. It's a tradition of this House, Mr. Speaker, sir, and I refer to the findings of this House in the Honorable Governor Sonko in a ruling delivered by the Speaker of this House on the 17th of December, which ruling barred the County Assembly of Nairobi from introducing any new evidence. It has been the tradition of this House to protect all the parties that appears before it, so that, Mr. Speaker, sir, justice will not only be done, but will also seem to be done. We move this House to have these documents expunged from record, and the National Assembly be barred from relying on these documents. Mr. Speaker, sir, if these documents will be admitted, we shall suffer prejudice in the sense that we shall have no ability, or we shall have been denied an opportunity to respond to the same. We urge you, Mr. Speaker, sir, to hold that these documents is new evidence, and we rely on Rule 19 of this House rules. Noting that, Mr. Speaker, sir, the rules guiding these proceedings today do not provide for how to deal with new evidence as and when the same is brought to the attention of the House. However, the rules guiding the proceedings in the impeachment of a governor or deputy governor provides that new evidence shall not be admitted. Further to that, Mr. Speaker, sir, permit me to bring to your attention the findings in the case, in the civil appeal number 21 of 2014, which was the case of Governor Wambora versus the County of Assembly of Embu. Mr. Speaker, sir, in that case, Justice Odiek, may the Lord rest his soul in peace, Chief Justice Martha Koome, as then was, and Justice Vishram held that these proceedings of the impeachment of a president or deputy president are paramateria to the impeachment of a governor. That is to say, they are identical. So what applies in those rules in the impeachment of the governor can equally and should equally apply to these rules. And finally, this House being a House of record, then we are bound by our previous precedents. I am most obliged.
Now, Counsel for the National Assembly, you have 1.5 minutes to respond. You may respond now, or you may respond after the lunch break.
All right. Mr. Speaker, sir, I could respond shortly after the lunch break.
Under our rules, we have to rise at 1:15.
Permit me then to respond after the lunch break. Most obliged.
So, honorable members, I will deliver ruling at 2:30 and then allow the Counsel for the National Assembly to proceed to respond to the second limb of the objection.
To you. This is a live broadcast brought to you by the Kenya Parliamentary Broadcasting Unit in conjunction with Kenya Broadcasting Corporation on this Wednesday, October 16th, 2024. In the order of business today, there's a procedural motion, exemption of business from the provisions of Standing Order 43. This is by the leader of the majority party, that this House resolves to exempt the business appearing as Order number 9, 10, 11, and 12 in today's order paper from the provisions of Standing Order 43, being a Wednesday morning, a day allocated for business not sponsored by the majority or minority party or business sponsored by a committee. A motion for consideration today is the consideration of Senate amendments to the Division of Revenue Amendment Bill, the National Assembly Bill number 38 of 2024. This is by the Chairperson, Budget and Appropriations Committee, that the Senate amendments to Division of Revenue Amendment Bill, National Assembly Bill number 38 of 2024 be now considered. There's also a motion for the alteration of the calendar and resolution to sit on a specified Friday. This is by the leader of the majority party, that pursuant to the provisions of Standing Order 28.4, calendar of the House, and 33, this House resolves to commence the short recess on Tuesday, 22nd October 2024, and hold sittings on Friday, 18th October 2024, commencing at 9:30 a.m. for the mornings. For 9:30 a.m. for the morning sitting and 2:30 p.m. for the afternoon sitting, for purposes of consideration, considering priority businesses, including mediated bills. Another motion set to be discussed in the National Assembly this morning is the consideration of mediated versions of the Water Amendment Bill, National Assembly Bill number 33 of 2023, also by the leader of the majority party, that pursuant to the provisions of Article 113(2) of the Constitution and Standing Order 153, this House adopts the report on the Mediation Committee on the Water Amendment Bill, National Amendment Bill, number 33 of 2023, laid on the table of the House on Tuesday, 15th October 2024, and approves the mediated version of the Water Amendment Bill, National Assembly Bill number 33 of 2023. The inquiry into regulations and illegal grant of tax exemptions to a company under the Special Operating Framework Agreement is also another motion sent to be discussed this morning. This is by the Chairperson, Committee on Delegated Legislation, that this House adopts the report of the Committee on Delegated Legislation and the inquiry into irregular and illegal grant of tax exemptions to a company under the Special Operating Framework agreement laid on the table of the House Thursday, 26th September 2024. Another motion to be discussed this morning is the comprehensive report of education bursary schemes to ensure free basic education in Kenya. This is a motion by the Honorable Esther Passaris MP, that aware that Article 43(1), as read together with the Article 53(1)(b) of the Constitution, provides that every person has the right to education and enshrines the right of every child to free and compulsory basic education. Further aware that Kenya Vision 2030 identifies education as a critical component for transforming the country into a global competitive nation. Appreciating that bursaries play a vital role in supplementing funding for enhancing access to education, particularly to students from disadvantaged backgrounds. Another motion to be discussed is the establishment of the Science Museum. This is by the Honorable John Kiare MP. And if you're just joining us, this is a live broadcast brought to you by the Parliamentary Broadcasting Unit in conjunction with Kenya Broadcasting Corporation. Just walking into the chamber is the Deputy Speaker, who will be presiding over the proceedings today, Wednesday, October 16th. Do enjoy your viewing. Have a lovely morning. My name is Doris Getonga.
Pray. Almighty God, who in your wisdom and goodness have appointed the offices of leaders and parliaments for the welfare of society and the just government of the people, we beseech you to behold with your abundant favor as your servants whom you have been pleased to call to the performance of important trusts in this republic. Let your blessings descend upon us here assembled, and grant that we treat and consider all matters that shall come under our deliberation in so just and faithful a manner as to promote your honor and glory, and to advance the peace, prosperity, and welfare of our country and of those whose interests you have committed to our charge. Amen. Sergeant at Arms, ring the bell for 10 minutes.
The Speaker of the day has called for a quorum bell to be rung for 10 minutes. This is to ensure there's enough quorum to start the business of the day. A quorum of the House or of a committee of the whole House shall be 50 members. This is according to the Standing Orders 34, which also says that if there's not a quorum present when the chair is taken at the time appointed for a meeting of the House, immediately after the saying of the prayer, the Speaker shall order the bell to be rung for 10 minutes, and if no quorum is present at the expiration of the 10 minutes, the Speaker may direct that the bell be rung for a further 5 minutes, and if there is no quorum present, the Speaker shall adjourn the House forthwith to the next meeting. I'll continue to take you through some of the business that is scheduled to be discussed this morning. There's the motion of establishment of the Science Museum, which is by the Honorable John Carrier MP, that aware that Article 11B of the Constitution provides that the government shall recognize the role of science and indigenous technologies in the development of the nation, further aware that the Vision 2030 provides for the integration of information, communication, and technology in the country's transformative agenda, concerned that exists no science museum for consolidating indigenous scientific and technological innovations, training and research purposes in the East African region, appreciating that integration of science and technology will greatly enhance Kenya's economic and societal success, noting that there is potential for growth in the technology sector by establishing a science museum, further noting that the informal science education plays a key role in the progression of science, technology, engineering, and mathematics, which is the STEM. Acknowledging that science museum operate as a nexus between science practitioners, policymakers, and the public, cognizant of the fact that a science museum in the country will greatly impact on the economy of the country in quest to becoming an industrialized nation. Now, therefore, this House resolves that the national government, through the relevant ministries, establishes and operationalizes a science museum in the country. This will be a resumption of debate that was interrupted on Wednesday, October 2nd, 2024, in the morning sitting. Another motion that is set to be discussed this morning is the National Sensitization and Support for Combating Sickle Cell and Hemophilia Disease. This is by the Honorable Peter Nabulido, MP. Also in the second reading this morning will be the Kenya Information and Communication. As indicated by the Sergeant at Arms, the quorum has been achieved. Allow me to hand you over for the live proceedings. Enjoy your viewing.
Okay, we may proceed, honorable members. First order.
Order number 1, administration of oath. Order number 2, communication from the chair. Order number 3, messages. Order number 4, petitions. Order number 5, papers. Order number 6, notices of motion. Order number 7, questions and statements.
Honorable members, allow me to reorder the order paper. We will move to order, instead of going to order number 7 now, let's go to order number 8, followed by 9, then 10, then we'll come back to order number 7. You may announce order number 8.
Order number 8, procedural motion, exemption of business from the provisions of Standing Order 43.
Thank you very much, Honorable Speaker. Honorable Speaker, I beg to move that this House resolves to exempt the business appearing as order number 9, 10, 11, and 12 in today's order paper from the provision of Standing Order number 43, being a Wednesday morning, a day allocated for business not sponsored by the majority party leader, of course, or minority party, or business sponsored by a committee. Honorable Speaker, let me take it again, Honorable Speaker, so that a day allocated for business not sponsored by the majority party and minority party or business sponsored by a committee. I beg to move, and then I will ask that we move this business that appears on number 9, 10,
Yes,
9, 10, 11, and 12. We move it, Honorable Speaker, as per Standing Order number 43, being a Wednesday morning, that is, of course, usually allocated for the leadership and the business sponsored by a committee, Honorable Speaker. So I beg to move, and then I will ask the Honorable Kuria Kimani to second, Honorable Speaker. Thank you.
Honorable Speaker, as our whip has said, we've lost quite a number of days in the course of this week and last week, and therefore it is important that we prioritize the government business and exempt today being a Wednesday morning sitting when it's meant for private members' discussions. Thank you, Honorable Speaker. I second.
Honorable members, I now propose the question that this House resolves to exempt the business appearing on order numbers 9, 10, 11, and 12 in today's order paper from the provisions of Standing Order 43, being a Wednesday morning and a day allocated for business not sponsored by the majority or minority party or business sponsored by a committee. Okay. Honorable members, I now put the question that this House resolves to exempt the business appearing on orders number 9, 10, 11, and 12 in today's order paper from the provisions of Standing Order 43, being a Wednesday morning, a day allocated for business not sponsored by the majority or minority party or business sponsored by a committee. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.
Order number 9, motion. Consideration of Senate amendments to the Division of Revenue Amendment Bill, National Assembly Bill number 38 of 2024. Question to be put.
Honorable members, I now put the Senate amendments to the Division of Revenue Amendment Bill, National Assembly Bill number 38 of 2024 be now considered. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.
Order number 10, motion, alteration of the calendar and resolution to sit on a specific Friday.
What is your point of order?
Madam Speaker, yesterday I was on the... No, let me finish. Tell them.
Let me allow him to. It's okay. Yes, there's a division, so we'll go to vote.
Madam Speaker, yesterday I was on the floor of the House when we were debating about motion number 9, and it was clear nobody supported this motion. I would beg you, I request you to repeat the question so that the members can make proper decision, Madam Speaker, on this matter. Thank you.
Okay, honorable members, I think what I'll do is put the question again because it means that members didn't understand. Okay, honorable members, I now put the question that the Senate amendments to the Division of Revenue Amendment Bill, National Assembly Bill number 38 of 2024 be now considered. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? Nay. The nays have it.
Order number 10, motion, alteration of the calendar and resolution to sit on a specific Friday.
You can move motion number 10.
Honorable members, I beg to move that pursuant to the provision of Standing Order number 28.4, the calendar of the House number and 33C, and that is the House of Meeting, that this House resolves to commence the short recess on Tuesday, 22nd October, and hold sittings on Friday, 18th October 2024, commencing 9:30 a.m. And that is for a morning sitting, and later in the afternoon, Honorable Speaker, we'll be having a 2:30 p.m. for the afternoon sitting.
Just read, just read the motion as is in the order paper. Don't add your own words.
For purposes of considering priority business, including mediated bills. Honorable Speaker, the rationale for seeking a resolution of the House to alter its calendar, it is that it's so that we are able to sit on Friday, 18th October 2024, arises from the fact that we need to recover time lost by the House on Mazingira Day, which was actually a public holiday last week, and the suspension of a sitting to allow public participation on the special motion. Remember when we had the public participation last week or the other week, I think it was last week, Honorable Speaker, for the proposed removal by impeachment of the Deputy President and the sitting used to consider the special motion. And also, Honorable Speaker, it is also due to the urgency to conclude certain priority business, pending before the House, pending in the House before we go for recess. And this includes, Honorable Speaker, the sugar bill, which is very crucial, that we really need to dispense on, the water bill, and the division of revenue bill that we've that is also that of course is going to be referred for mediation as going by the voting this morning, Honorable Speaker, and any other mediated bills, Honorable Speaker, that are going to be received in the course of the week. Honorable Speaker, we'll also use the opportunity to list for second reading several individual private members' bills, and that is of course pursuant to Standing Order number 141. This bill, currently, they total, they're actually 52 in number and are likely to lapse when the House proceeds for recess on 6th December, if not concluded for their second reading. And that is why it's very important, Honorable Speaker, for us to do that. And then there is also need to provide room for the House to consider any other urgent business, Honorable Speaker, that may arise requiring expedited considerations, Honorable Speaker. So, I beg to move that, and I will ask the Honorable Emmanuel Wangwe to second.
Honorable Speaker, I rise to second the motion by the whip majority party that, Honorable Speaker, we alter the calendar as he has moved the motion. Honorable Speaker, just citing only one bill, which is in mediated version, which I'm the chairperson, the sugar bill, Honorable Speaker. I want to present the paper laid this afternoon. And Honorable Speaker, now that the majority whip has put it into consideration, my people will be waiting to see that this bill goes through. So my absence from the constituency because of moving this bill will be value for money, and I'm pretty sure my people will be happy and Kenyans will be happy. I second the motion.
Now propose the question. I now propose the question that pursuant to the provisions of Standing Order 28.4, Calendar of the House, and 33C, Hours of Meeting, this House resolves to commence the short recess on Tuesday, 22nd October 2024, and hold sittings on Friday, 18th October 2024, commencing at 9:30 a.m. for the morning sitting and 2:30 p.m. for the afternoon sitting, for purposes of considering priority business, including mediated bills. Honorable members, I now put the question that pursuant to the provisions of Standing Order 28.4, Calendar of the House, and 33C, Hours of Meeting, this House resolves to commence the short recess on Tuesday, 22nd October 2024, and hold sittings on Friday, 18th October 2024, commencing at 9:30 for the morning sitting and 2:30 p.m. for the afternoon sitting, for the purposes of considering priority business, including mediated bills. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. We can now go back to order number 7.
Order number 7, questions and statements.
We have a request for a statement by the Honorable Mohammed Bidu, member for Isiolo South. Is he here? Okay.
Thank you, Madam Chair. Honorable Speaker, pursuant to the provisions of Standing Order 44.2c, I wish to request for a statement from the chairperson of the Department Committee.
Apologies, Honorable Bidu. I'm sorry. I realize that we actually have questions. So let's start with the questions and we'll come to statements. I've seen the order paper. We do have questions. So we'll start with the questions, then we'll go back to statements. So you may sit down. You'll have your turn in a minute. Okay, so there's an ordinary question by the Honorable Member for Nyandarua, Honorable Faith Gitau, to ask the National Police Service. You may proceed, Honorable Gitau.
Thank you, Honorable Speaker. I wish to ask this question. When will Police Constable Nelson Wahome, PF number 36703, who was unfairly dismissed from the service in September 1990, be reinstated despite being acquitted by the Bugoma Court Vide case number 2076 of 1990? State the timelines within which Mr. Wahome will receive payment for outstanding salaries and benefits for the period he has been out of employment, as well as compensation for the unwarranted violation of his labor rights as guaranteed under Article 41 of the Constitution. Thank you, Honorable Speaker.
This question is to be replied by the Departmental Committee on Administration and Internal Security. How much time do you require, Honorable Tongoyo?
Considering that the House will be going on recess, possibly 2 weeks when we resume.
Thank you. We now have a question from the Honorable Member from Mbeere North, Honorable Ruku. He's not here. So we'll skip the question. He loses the opportunity. And the next question is also by the same member from Mbeere North, Honorable Ruku. In the absence of the member, we shall skip those two questions. We shall now go back to statements. So, Honorable Bidu, you can now make your request for a statement.
Thank you, Madam Speaker. Honorable Speaker, pursuant to the provisions of Standing Order number 44, 2C, I wish to request for a statement from the chairperson of the Departmental Committee on Administration and Internal Security regarding the tenure and transfer of the Deputy County Commissioner for Garbatula in Isiolo South constituency. Honorable Speaker, the National Government Coordination Act 2024 provides for Deputy County Commissioner in respect of every sub-county, mandated with coordinating national government functions at the sub-county level. It is with great concern that I raise the issue of deteriorating security situation in Garbatula's Isiolo South constituency and failure by the Deputy County Commissioner and his team of the area to adequately address the issue. Over the past 5 years, residents of Garbatula have faced rising cases of insecurity and have persistently appealed to the Deputy County Commissioner, Mr. Stephen Nyakundi, to address the issue to no avail. This issue has negatively impacted the social economic lives of the residents, including a 5-year closure of Bisanadi Primary School, Corbesa School as a result of unmitigated conflicts between feeding communities in the region. Just recently, the Ministry of Interior and National Administration announced transfer of Deputy County Commissioners, including that of Mr. Nyakundi. However, in a quick turn of events, his transfer was reversed, which makes this the 4th time this has happened in the last 7 years. Consequently, this has sparked public outcry as the residents believe that the Deputy Commissioner has failed to fulfill his mandated duties, particularly in maintaining peace and fostering cohesion within the sub-county level. Honorable Speaker, it is against this background that I request for a statement from the chairperson of the Departmental Committee on Administration and Internal Security on the following. Reasons for the repeated reversal of the transfer of the Deputy County Commissioner for Garbatula, despite demonstrable failure by the DCC to end the persistent insecurity in the region. Number 2, measures being taken to effect the transfer of the DCC of Garbatula in Isiolo South constituency and postal replacement. And number 3, strategies put in place to enhance the transparency and efficiency of the transfer process of national government administrative officers to ensure that they are in a position to serve their assigned regions effectively. Thank you, Madam Speaker, for giving me the opportunity. Thanks.
Okay, the question shall be responded to by the Departmental Committee for Administration and Internal Security. Honorable Tongoyo. How much time?
Okay, of course, Honorable Speaker, when we come from recess, but with actually a lot of respect to the rule of the House and the Honorable Member, listening to what he was saying, this is purely a human resource issue that I think will not have really warranted to be put as a statement, because the Ngawa office, or the officers who are responsible with the issue of placement and transfers of our officers, their offices are actually open. And they do this based on merit on individual cases. So I would rather challenge or ask them, Honorable Member, if we found it fit, just get to the office of the Administrative Secretary Administration and discuss even the issue. It's more better even if approached in that manner.
Okay, I think he's noted that point, but nevertheless, because the member has sought a statement to this, just put in the request.
Well guided.
Yes, he's going to either have the committee will make sure they get the report, the response for you. So 2 weeks, Honorable Tongoyo? Okay, thank you. I know you don't have to wait after recess. You can actually send out, because the government is not on recess. So if you send out the letter today, then by the time we come back from recess, the response will be there. So you can't put the country in recess also. Thank you. The next question is by the Honorable Member, nominated Member Abubakar Talib. Honorable Bidu?
Yeah.
Yes?
I have tried to go to that office severally. 4 times the transfer has taken place.
Honorable, because you're out of order, allow him to proceed.
When do I go? Can I be given assurance, Madam Speaker?
Yes. Honorable Member, I've already ruled that the chairperson will send out the letter today or tomorrow, and then by the time we come back from recess, there should be a response. So it's sorted out. Thank you. What's your point of order, Honorable Russo?
Thank you very much, Madam Speaker. Madam Speaker, I respect your ruling on this matter. But as the Honorable Chair has already affirmed, this is a human resource issue. And what the Honorable colleague is saying is this particular DCC has overstayed in that area. And as a result, the citizenry are up in arms, complaining. And that is why some things are administrative. They don't have to come to the floor of the House. But I believe as a committee, we will also pursue so that it doesn't really waste the time of the House when it can be done by the ministry. Thank you, Honorable Speaker.
Okay. Honorable Member, that's a point noted, but let's allow the relevant State Department to do that response to the member, not yourselves. Now you're acting like the State Department. I think if the member wants the response from them, I think that's a good point, especially if it's been pending. So let's move to the next request for statement by the Honorable nominated Member Abubakar Talib.
Thank you, Honorable Speaker. Honorable Speaker, pursuant to the provision of Standing Order 44-2C, I rise to request a statement from the Chairperson of Departmental Committee on Finance and National Planning regarding the abrupt termination of operation by Direct Line Assurance Company Limited. Honorable Speaker, on 10th September 2024, Direct Line Assurance Company Limited announced the immediate cessation of its insurance business operation. In the announcement, the company stipulated that any further transaction must be conducted through its original shareholders. This development has raised significant concerns about the stability of the insurance sector and the welfare of policyholders across the country. Furthermore, it has created widespread confusion and uncertainty in the market, potentially affecting thousands of policyholders and the broader public. Honorable Speaker, it's against this backdrop that I request for a statement from the Chairperson of the Departmental Committee on Finance and National Planning on the following. Provide a comprehensive report on the current status of Direct Line Assurance Limited, including detailed information on its ownership, shareholding, and number of policyholders. Clarification on legal status and validity of insurance policies issued by Direct Line Company Limited, particularly on the coverage and protection to vehicles and passengers in the event of an accident. Plans put in place to ensure that claims made by motor vehicle owners insured by Direct Line Company Limited are processed. Measures being taken to ensure that all vehicles with valid insurance covers from Direct Line Assurance Company can operate without hindrance for the duration of their policy validity, and plans put in place to prevent future cases where the financial instability or closure of an insurance company could adversely affect the operability of insured vehicles and the safety of passengers. Thank you, Mr.
Chairperson for the Departmental Committee on Finance and National Planning.
Thank you very much, Honorable Speaker. And from the onset, I would like to thank the Honorable colleague for bringing this matter to the attention of this Honorable House and to the attention of our committee. I know this is a matter of public concerns where several people are taking insurance coverage, but when it comes to the time to be compensated, then that challenge exists. And Honorable Speaker, without preempting maybe what the committee will do, the situation that's happening with direct line insurance is very unfortunate and should not happen in the first place. Because in any case, there exists a policy compensation fund where in the event something happens to an insurance company, whether insolvency or whatever challenge that come, then the person to the insurance policy holders should not be the one to suffer any loss. And therefore, maybe given the short time of recess, in another 3 weeks, we should be able to come back with a response to this Honorable House, hopefully to the satisfaction of the Honorable Member. Thank you, Honorable Speaker.
Thank you. And now we go to the request for statement by Honorable Joyce Kamene, member for Machakos County.
Thank you, Madam Speaker. A request for a statement regarding the delay of disbursement for the National Government Affirmative Action Fund for Machakos County. Honorable Speaker, pursuant to the provision of Standing Order 44-2C, I rise to request for a statement from the Chairperson of the Department Committee on Social Protection regarding the delays in disbursement of the National Government Affirmative Action Fund, GAF, for Machakos County. Honorable Speaker, GAF is a cornerstone for our government's commitment to inclusive development by providing access to financial resources for socio-economic empowerment for the women, youth, people living with disability, needy children, and the elderly. Through the fund, many of our young men and women have found reliable avenue for promoting their enterprises and value-additional initiatives, making it instrumental in transforming lives. Owing to the crucial contribution of affirmative action initiative in our societies, it is important to ensure timely disbursement of such funds and proper structure for its efficient administration. Sadly, Honorable Speaker, Machakos County continues to face inexplicably delay in disbursement, leading to accumulation of unspent balances for the financial year 2022-2023 and 2023-2024. GAF has been deploying Madam Betty Kanyiri Njoni of personal number 2009-1421-27, Principal Gender Officer, as the county coordinator on extremely short acting contracts. These inexplicably intermittent deployments, separated by incoordinate delays spanning as long as 2 months for GAF to renew the contract, continues to cause serious administrative gaps that significantly disrupts effective administration of the fund. Honorable Speaker, it is against this background that I request for a statement from the Chairperson of the Department Committee of Social Protection on the following. A report on the status of disbursement of the GAF balances for the financial period of 2022-2023 and 2023-2024 to the Machakos County, and the measures put in place to ensure timely disbursement to enable the continuation of projects approved for funding, and action being taken by GAF to immediately post Ms. Betty Kanyiri of personal number 2009-14-21-27 as the GAF County Coordinator for Machakos County for an interrupted contract for at least 1 year in order to ensure effective and seamless administration of the fund, including the timeline of the posting. Thank you, Honorable Speaker. Signed, Honorable Joyce Kamene Kasimbi. Thank you, Madam Speaker.
Thank you very much, Honorable Kamene. This question is referred to Committee on Social Protection. Is the chair in the House? In the absence of the chair, the vice chair? In the absence of the vice chair, then I would like to pass this to the leadership. When can the Honorable Kamene get a response? Honorable Osoro. In the absence of the chair and the vice chair, Social Protection Committee, to which this question by the Honorable Joyce Kamene is referred, I would like you to tell us when she can get a response.
Thank you very much, Honorable Speaker. Honorable Speaker, I commit to whip the chair of the relevant committee, and I promise that with my push, we'll be able to get the answer once we resume back from recess. That should be about 2 weeks from now.
Honorable Kamene, is that acceptable to you, the first week when we come back from the recess?
Chair, Madam Speaker, I wish we'd have gotten an answer in the next 24 hours because we'll be going for recess, and these are balances that are within the headquarters of GAF, and I'll be at the ground, nothing doing, without even a coordinator, and you can easily remember that we had gone for another recess. I had nothing to do in the ground because we do not have these funds, and funds are available and they're at the GAF headquarters. Can I please get a better answer? Thank you.
Well, Honorable Kamene. Yes, do you want to respond to the Honorable Kamene?
Yeah. Honorable Speaker, I am just holding brief for the chair. I really do not want to make a commitment, Honorable Kamene, that I won't deliver. Please indulge me and allow me to push the Honorable Member to be able to do the response in just 2 weeks. It is not very long, Honorable Kamene. Immediately after actually we go for recess, you'll find a lot of other engagements with the great people of Machakos, and I'm sure you'll be so much committed, and you'll utilize the funds in the long recess that will be going just after we resume back. You can now be doing the capacity building and all the other things. Thank you very much, Honorable Kamene. Thank you, Honorable
Well,
Speaker.
before I go to Honorable Kamene, what is out of order member for Tiati?
Madam Speaker, while I appreciate Honorable Osoro giving responses here on behalf of the chair, I am finding it difficult to understand the role of Honorable Osoro. Madam Speaker, Honorable Osoro is a majority whip. And a few minutes ago, the majority leader was here. What role is Honorable Osoro playing in this House?
So I want to ask you, Honorable Member for Tiati.
Can we be told
what is out of order, Honorable Kamket?
What role
is out of order?
Is Honorable Osoro playing? The majority leader has been around, and It looks like the Honorable Soro is acting majority leader. I do not know what's happening. Can you explain to us what is happening in the leadership of the Assembly?
Well,
are there changes that we do not know about? Can we be informed of what is happening?
what is out of order then?
We want to know whether there are changes in the leadership, Madam Speaker, because the majority leader is here.
Well, there's nothing out of order, Honorable Kamuket. For sure, there is nothing out of order. And I was able to watch the body language of the member for Machakos as she was being engaged by the Honorable Soro. And I would like to request for your patience that you get the answer in 2 weeks, so that you don't get commitments that are not possible, especially when we are on recess. Thank you, Honorable Member for Machakos. Next. The Honorable Abdul Haro, please proceed with your question.
Honorable Speaker, pursuant to the provisions of Standing Order 44.2c, I wish to request for a statement from the chairperson of the Departmental Committee on the Tourism and Wildlife regarding the increase in wildlife attacks in Mandera County. Honorable Speaker, over the past 5 years, Mandera County has witnessed an increase in human-wildlife conflicts. Many residents and their livestock have fallen victim to attacks by crocodiles, hyenas, and snakes, which has in turn caused physical, emotional, and financial devastation to the affected families. One such case is that of Mr. Ibrahim Abdullahi Ali of ID number 6411601, who was attacked by a hyena in a Babosone location on 27th June 2023, resulting in the loss of his right arm. His family, burdened with significant medical expenses, has been forced to seek specialized treatment in Awasa Hospital in Ethiopia. Similarly, Ms. Fatuma Nur Ali, a young woman from Abeyumur village in El Ram location, lost her life to a snake bite on 24th May 2016. Her case was duly recorded through the Kenya Wildlife Compensation Claim Form, serial number 694/MDR/2016, and submitted to the KWS Mandera County for processing. Unfortunately, 8 years later, her family is yet to be compensated. These incidents underscore a need to address and safeguard the well-being of residents of Mandera County. Honorable Speaker, it is against this background that I request for a statement from the chairperson of the Departmental Committee on Tourism and Wildlife on the following. 1. A comprehensive report on the support being provided to Kenya Wildlife Service to ensure prompt responses to distress calls in Mandera County. 2. A report on the immediate and long-term measures that the government has put in place to mitigate the recurring human-wildlife conflict in Mandera. 3. An update on the compensation status for the families of Mr. Ibrahim Abdullahi Ali and Ms. Fatuma Nur Ali, including specific timelines for the settlement of their claims. And 4, measures put in place to streamline and expedite the compensation process to ensure timely and fair compensation for all victims of wildlife attacks. Thank you, Honorable Speaker.
Member for Mandera South. This question is referred to the Departmental Committee on Tourism and Wildlife. Is the chairman in the House? In the absence of the chair, the vice chair? I see a hand from the Honorable Kilel. I would like to pass it to the House leadership. Let me pass this to the Honorable Soro. It is tourism and wildlife. Question asked by the Honorable Abdul Haro, member for Mandera South.
Thank you very much, Honorable Speaker. Honorable Speaker, I also wish, just like the other one, in the absence of the chair and any member of the committee, I want to make an undertaking that the member will get a response once we resume back from recess, Honorable Speaker.
Honorable Harrow.
Honorable Speaker, I stand guided.
Thank you. Next order. So now, honorable members, will go to the Honorable William Kamket, member for Tiati. It's a response to a question.
Honorable Chair, I think it's the chairman to respond to the statement. Yeah.
Thank you so much, Honorable Chair. As I did promise yesterday to respond to the very statement being sought by the Honorable member for Tiati, here I want to issue the statement. Honorable Speaker, the member for Tiati constituency, Honorable and the only one, William Kamket, had requested a statement regarding the review of scheme of service for the appointment of chiefs and assistant chiefs in marginalized areas. And the honorable member particularly sought to be informed, one, whether the Ministry of Interior and National Administration could consider a review of the academic qualification for appointments of chief and assistant chiefs in marginalized areas. Two, whether the ministry could consider experienced individuals from the respective location and sublocation in the recruitment of chiefs and assistant chiefs on the basis of affirmative action. And I respond as follows, Honorable Speaker. The appointment of chiefs and assistant chiefs is guided by the reviewed scheme of service for the National Government Administrative Officers 2015 that explicitly set the minimum qualification for appointment as follows. Assistant chief, for appointment to this entry grade, a candidate must have the following qualification. Have a Kenya certificate, secondary education, KCSE, mean grade of C-, or its equivalent from a recognized examining body. Be not less than 30 years of age. Be a resident of the particular sublocation. Police should have produced a police clearance certificate, have a good communication skills, and have a certificate in computer application skills from a recognized institution. Honorable Speaker, for the position of the chiefs, to be appointed to this entry grade, a candidate must have the following. Have a Kenya certificate of secondary education, KCSE, mini grade of a C, or its equivalent from a recognized examining body. A diploma in any of the following disciplines: public administration, management, social work, community development, education, governance, conflict management, or its equivalent from a recognized institution, and be not less than 5 years of age, and be a resident of the particular location, with, of course, also the issue of the police clearance certificate of good conduct, have good communication skills, and have a certificate in computer application skill courses for the recognized institution. However, and I repeat, Honorable Speaker, however, in specific circumstances where the advertised position do not attract qualified candidates, the ministry on need basis request academic waivers from the public service to facilitate the filling of these vacancies. The Public Service Commission always grants such academic waivers on request. The other thing that the member wanted to know is whether the ministry could consider experienced individuals for the said position. Honorable Speaker, whereas possession of experience in social, political, economic, and cultural aspects of communities is important in public administration at the grassroots, all cadres or positions in public service are subject to particular minimum academic requirement during recruitment and selection process. As already indicated, the use of academic waivers in special circumstances is in itself an affirmative. And I underline that. This affirmative action ensures that citizens in the marginalized areas are not discriminated, but have an equal access to the chiefs and assistant chiefs position. Thank you, Honorable Speaker, and I submit.
The Honorable Kamket, is the response satisfactory?
The Honorable Speaker, while I appreciate the response from the chairperson, this policy, Honorable Speaker, as he has stated, began in 2015. And from then, Honorable Speaker, the position of the chief and assistant chief, which is a very important position in government, has been completely watered down. And in places where some of us come from, Madam Speaker, very many young people have been disenfranchised. And this policy, Honorable Speaker, the policy that the Public Service Commission came up with is a very punitive policy. It is anti-people, it is anti-hustlers, and it's a policy that never underwent any public participation. And in my request, Honorable Speaker, I specifically asked the ministry whether they could consider a review. But what they have said is that they have special circumstances where they ask for academic waivers. What if, Honorable Speaker, those people are not available? We have in this republic, the Republic of Kenya is not equal. We have places where you cannot get somebody who has finished Form 4, let alone somebody who has a C- or a C stand. I have asked for a specific policy review because this one never underwent public participation. Madam Speaker, I am asking and I'm demanding that this policy be reviewed. Otherwise, we are going to challenge it in court. Honorable Speaker.
You want to ride on that before I give the chair? So then I start with the Honorable Dr. Pukose.
Thank you, Madam Speaker. Madam Speaker, on this issue that has been raised by the member for Tiati, I wanted to ask the chair whether these academic waivers only apply to marginalized areas or to all other areas where people with minimum qualifications as stipulated for assistant chief or chiefs are not acquired. Then the second one is recently we had cassettement of divisions, locations, and sub-locations, and those have not been operationalized. When are they going to be operationalized? Thank you, Madam Speaker.
Well, then on the same, I would like to give a chance to two more people, then we end it at that. The Honorable David Bowen, Marakwet East, followed by the Honorable Peter Lochakampong. Those two.
Thank you, Honorable Speaker. Honorable Speaker, I want to support the Honorable Kamket. And specifically to that policy that requires some specific academic qualification for chiefs or assistant chiefs. Madam Speaker, many parts of this country, in the northern Kenya, in the northern frontier, all the way to Turkana, I want to tell you, Madam Speaker, it is true that you can go to a sub-location and you may not find someone who has finished their Form 4. And that place requires an administrator. And you know, Madam Speaker, the reason why some of us from the pastoral community, there are so many insecurity and this banditry, because there are no administrators. The government is far away from the people. So if we want to bring services closer to the people, the services are for a chief or an assistant chief. Madam Speaker, I think that policy needs to be reviewed so that we can see if there is no one in that location or sub-location who has not finished Form 4, Madam Speaker, we can consider even someone who finished Class 8 and is able to do the job. So I want to ask my colleague, the Honorable Chair, that he can still go back to the ministry and give us a very concrete answer. Thank you, Madam Speaker. At the same time also, with what the Honorable Bukosa said, Madam Speaker, there are so many administrative units which were cascaded, locations, sub-locations, and divisions. Like recently in my place, the Honorable Speaker, the Kerio Valley sub-county, they operationalized the sub-county and posted a deputy county commissioner, and they have not operationalized the divisions, the locations. So you have a deputy county commissioner who is without the assistant county commissioners, who is without chiefs. How is he going to operate?
Well, thank you. You made your point. Members, I had agreed to give to the Honorable Lochakapong. It 1 minute.
Yeah,
1 minute, please.
Thank you, Honorable Speaker. I want to commend Honorable Kamket for bringing up this matter. And this is something that is affecting many parts of this country, especially the pastoralists. Where I come from, this is a big problem. To get somebody who has C- to be an assistant chief. And while still, Honorable Speaker, you have even, the chair has even communicated that for a chief, it's a seaplane. And in the spirit of promoting an assistant chief, probably who was recruited with a C-, on the exit of a chief, it becomes very difficult. And Honorable Speaker, even where he is saying that academic waivers are issued in some special circumstances, sometimes it is not forthcoming. So we have had challenges, Honorable Speaker, and I want to say this, that that policy needs to be reviewed. If, Honorable Speaker, for somebody to contest to be even a member of this House, there is no academic qualification required.
The Honorable Nicholas Ngikolong, Turkana East, and the last one.
Thank you, Madam Speaker, for giving me this chance to support the statement by Honorable Kamket. Madam Speaker, this issue of chiefs and the assistant chiefs in those marginalized areas, it is really something which is supposed to be looked at by the Ministry of Interior. Madam Speaker, I am a son of a chief. And I'm in this house because of the reward the people of Turkana gave me because of my dad. The job he did in that place, and that's why I'm here, the member of parliament. Madam Speaker, my dad, he was just a mere pastoralist. And he was given that position. And he did a good job. And that's why the people of Turkana reward me because of the good job my dad did. Why is this issue of the C- or the seaplane coming from when we want to recruit a chief? Madam Speaker, this policy is supposed to be reviewed so that everybody can be given a chance. When we talk of those places, we don't have even schools in some areas. How can we get a C- in those areas when we don't have a school in those areas? And there is also in the same policy,
it's okay. You made your point, Mheshimiwa. So, Beatrice, I would like very kindly, let's go back to the chair so that we can close this. Chair.
Thank you, Honorable Speaker. I've really had the members who had actually raised their concern. And Honorable Speaker, I know the subject matter is a very, of course, elicited a lot of interest across across the House and even in the nation. But Honorable Speaker, I want to state that that is how it is at the moment. And I think we had actually laid it very clear that the issue of waiver is applying. If probably there could be delay, it could be attributed to individual officers who are responsible by doing the so. Let me make my point, Honorable Kamket.
Order, Honorable Kamket.
Because even I know quite a number.
Please be orderly so that, no, I would like him to first of all respond to you,
Honorable Speaker,
No,
just
if you have
protect
a
me
further-
from...
If you are if you are not satisfied, you can also say that you are not satisfied. But let's give him
Yeah,
time
so
to
what
finish.
I'm saying, actually, Honorable Speaker, I'm in total agreement with the concern of members. That is true. In majority of these hard pastoralist communities or some areas in this country, to get even a C- is a problem. And even the people who probably has these grades are the people who actually probably are in Nairobi, are in towns, and the role of the chiefs needs somebody who knows the issues, the local issues in the community. But having said this, Honorable Speaker, I want to say nothing is cast on stone. That is how the scheme is at the moment. This House has the powers also to review if need be. But at the moment, this is how it is. Maybe the honorable members can as well look into the means that the scheme and such kind of policies and regulations can be reviewed. I'm actually also in support that maybe we need to reconsider this.
Well, before the Honorable Kamket speaks, Honorable members, let us bear with the chairs of committees because the chair is reading a response from the ministry. And I believe that the chair has agreed with the members that there is need for change of policy. So with that, one more minute, Chair.
Yeah, add me 1 minute. So I think to be on record, I really understand. And I personally come from a pastoralist community. And I know how important this thing is. That majority of the most competent and more efficient officers could be actually the people who could have been staying in that area for too long, understand the local issues, policies, and even local issues. Lastly, on the issue of administrative unit, Honorable Speaker, this is an issue that I think the honorable member is supposed to have written a statement. Nevertheless, we all know that this thing boils back to the issue of finances and availability of resources. The issue of Kerio Valley, as being said by Honorable Bowen, we know this is something that was, of course, already done because of the insecurity in the region. And it has really helped a great deal. The issue of the small unit, it is just a factor of resources and money. We all know that the vacation of finance bill did a big deal to the operationalization of this unit. So moving forward, I know good days are ahead. When we move into the supplementary budget probably coming up too, we'll consider to allocate resources to operationalize on need basis, Honorable Speaker.
I would like you to be on record. I would like Chair to be on record on the matter of need-to-need basis. Is it operationalization of existing, which have been gazetted? Or
Yes, Honorable Speaker. The gazette, there are quite a number. The backdating actually 2017. Because of the constraint of resources, quite a number has not been operationalized. So we are going to do it gradually, depending on availability of resources. Yeah.
has already agreed with you. There is no need to pull this further because it's not a debate, but because the question belongs to you, I'll give you 1 minute. Please pass the mic. Please pass the mic to the Honorable Kamket. Other members, please bear with us because we have to move to the next order.
Thank you, Honorable Speaker. Honorable Speaker, we have an interesting situation here. The chair himself does not believe in the answer, in the reply he has brought to the House. The chair agrees with me and agrees with the rest of the members that this policy needs to be reviewed. So now, why does he bring a statement to the House that he does not even believe in it? So, Madam Speaker, may I request, Madam Speaker, if this was a regulation, we would have looked for ways of repealing it. But this is a policy that is done by the ministry. Would I be in order, Madam Speaker, that you order this chair to call for a meeting where the Cabinet Secretary, the Public Service Commission appears before the committee, and then we come and address this matter holistically. Because as it is now, even the chair does not believe in the statement he has brought. He agrees with me.
Chair.
For Honorable Kamke to say that I don't believe in what I'm reading. That is, of course, very wrong. What I've said actually the concern of the members from the pastoralist community, where I personally also come from, I really totally in agreement with the concern they are raising. What I had also said to be on record, that nothing is cast on stone. Police can be reviewed depending on merit and when on need base. So that is exactly just what I've said. And the honored member is a senior, you are a ranking member in this house, and you know the procedures. You know if there are need to review the regulation and policies and the scheme of service. So you have made your point as guided by the speaker. We are going to, of course, able to scale it up and see, because it has to be between the ministry and the public service, which actually is the custodian of the schemes.
Thank you, Chair. I would like you to take a seat. I would like Honorable Kamket to take your seat. So then, honorable members, I order that this matter be discussed further by the Committee on Administration and Internal Security. In this committee, the Cabinet Secretary or the PS, if the Cabinet Secretary decides that the PS be there, but also Public Service Commission to be there, and let this matter be discussed by the committee. So thank you. Honorable Kamket, you please take your seat. Kamket, oh, you are being disorderly, Honorable Kamket. Honorable Kamket, you are being disorderly, and you know this is your third term in this house. Is it your third or your fourth? Second. I thought that you are third term. So, Honorable Kamket, if after this matter is discussed by the committee, the chairperson will bring a report in this house. And I hope that this will not be for pastoral communities only, because this matter affects many other areas of this country. Thank you. Chair Education. Next will be Chair Education, responding to the Honorable Doris Donya, member for Kisii County. And she has been patiently waiting. I do not see the Chair Education in the House.
Honorable Speaker, with your permission, I will read the response.
You have the response, please proceed.
From the chair of on behalf of the chair of the Education Committee. The question was the strategies that Ministry of Education has put in place to ensure that schools adhere to set regulations, including prohibiting tuition during weekends. Honorable Chair, the Ministry of Education in Kenya has implemented various strategies to ensure that schools adhere to regulations prohibiting tuition during weekends and school holidays. Some of the key measures include: 1, circulars and guidelines. The ministry regularly issues circulars reminding schools and stakeholders of the ban on extra tuition, which we first imposed in 2012. The circulars outline the guidelines prohibiting any form of tuition during weekends, public holidays, and school vacations. 2, through the Directorate Quality Assurance and Standards Directorate, the ministry conducts routine inspections of schools to ensure compliance. Officers from this department visit schools, particularly during weekends and holidays, to check if extra tuition is taking place. 3, reporting mechanisms. The ministry has established reporting mechanisms where parents, students, and the public can report cases of schools that violate the ban on tuition to the sub-county field offices. 4, public awareness campaigns. The ministry has rolled out public awareness campaigns to educate parents and students about the importance of rest for learners and the regulations on tuition. These campaigns aim to discourage parents from asking for extra tuition. 5, engagement with stakeholders. The ministry regularly engages with key stakeholders to ensure collective responsibility in enforcing the ban. These dialogues help ensure that both educators and parents are aligned with the government's policy on the matter. These efforts are part of the ministry's broader agenda to promote a balanced learning environment and prevent the overburdening of students. On question 2, the question 2 was on the plans the Ministry of Education has put in place to ensure that public and private schools that pick and drop students have sufficient vehicles to avoid long travel time to and from school going children. And the response is as follows. Honorable Chair, education in Kenya has taken several steps to address the issue of school transportation, especially concerning the adequacy of school buses for both public and private schools. These strategies aim to ensure that students are safely picked up and dropped off without facing long distances or delays. 1. Transport guidelines / circulars for schools. The Ministry of Education has developed guidelines for school transport to streamline the management of school buses. These guidelines / circulars encourage schools to ensure that they have sufficient buses that comply with safety standards and adequately serve their student population. Schools are required to ensure that buses are properly maintained and the journeys are properly planned. 2. Encouraging schools to purchase buses. Public schools have been encouraged to prioritize the purchase of school buses through government funding, the Constituency Development Fund, and contribution from parents and alumni. Schools that already own buses are urged to increase their fleet to serve the growing student population. The ministry emphasizes this as part of the infrastructure development necessary for competency-based curriculum CBC rollout. 3. Monitoring and auditing school transport systems. The ministry's Directorate of Quality Assurance and Standards is tasked with the safety of learners and transport system of learners and transport systems in schools to ensure they meet the required standards. Schools are checked for sufficient transportation resources and long pickup or drop-off distances are discouraged. 4. Engagement with parents and school boards. The Ministry of Education worked closely with parents and school boards to address transportation challenges. Parents are encouraged to participate in discussions with school administrations regarding the transportation needs of students. This includes raising funds for additional buses in cases where schools face logistical issues related to the insufficient transportation. 5. Partnership with the National Transportation and Safety Authority, NTSA. The ministry collaborates with the NTSA in ensuring that school buses adhere to the required safety standards, including the appropriate routes and operational hours. This partnership helps enforce the use of buses that are safe, properly licensed, and capable of serving the school's catchment area effectively. 6. Government-funded school buses. The ministry has worked through government programs, including the National Government Constituency Development Fund, NGCDF, and county government funding to assist public schools in purchasing school buses. This initiative focuses on equipping public schools with the necessary resources for transportation, particularly in rural and marginalized areas where transport infrastructure may be underdeveloped. NGCDF has been instrumental in funding the acquisition of school buses in numerous constituencies, with members of parliament actively supporting these initiatives. These buses are meant to serve students in areas where public transportation is limited, reducing the burden of long walking distances or the need for students to use unsafe or expensive alternative means of transport. 7. Transportation safety and capacity regulations. The ministry, in collaboration with NTSA, has implemented stringent rules regarding the capacity and operation of buses. These regulations mandate the school buses must not exceed their passenger capacity, should adhere to specific operational hours, no night travel for school buses, must have proper safety equipment such as seat belts for each seat. School found violating these regulations, such as overcrowding buses or allowing unsafe travel conditions, are subject to penalties, including fines or revocation of their bus permits. This ensures that the available buses are used to efficiently and safely reducing transport risks. Number 8, capacity building and training for school bus drivers. The Ministry of Education, in partnership with NTSA, conducts capacity building programs for school bus drivers and transport managers. These training sessions focus on enhancing road safety awareness, improving route planning to minimize long travel times, encouraging adherence to transport regulations specific to school vehicles. Trained drivers and transport managers can better organize student pickup and drop-off schedules, avoiding unnecessary delays or long routes that might strain the transport system. 9, community and stakeholder involvement. Schools are encouraged to involve the local community, parents, and alumni in solving transportation challenges. Fundraising initiatives and alumni contributions have been successfully employed by many schools to purchase additional buses or maintain existing ones. In some cases, local buses or organizations sponsor school buses as part of their corporate social responsibility CSR efforts. The ministry is in the process of developing a schools transport policy to guide in implementation of various interventions outlined above to entrench a culture of safe and secure transport system for all learners. Signed, Florence Amoit, Principal Secretary, for Principal Secretary. Thank you.
Thank you very much. The Honorable Donya.
Thank you, Madam Speaker. I've just followed on what was reading, and I just wish, instead of reading all those things, because to me, they have not made any good sense. You could have even answered my question with the last point. The Ministry of Education is going to look on ways to form a transport policy. That could have worked better. Reason, Madam Speaker, there are schools where learners wake up at 3:45 a.m. They are in school. We see them by the roadside. Members of Parliament wake up very early to go for games. By 5, our children are early. They are in buses going to schools. He is saying they consider and make sure that they are not overcrowded in buses. I don't know if he was reporting for Kenya or Uganda. Every day, if you are on the road, you will see school buses overcrowded. So you've just read things that are on paper, but they are not on the ground. And on reporting to school time, the Committee on Education, you could even have called me and asked, Donya, which schools are these? I would have given you a list of schools. You go there with papers, you give learners. They do like you put in a suggestion box. What time do you wake up? What time do you come to school? So I give it back to you. You've not answered what I had asked. What you've reported to me is what you have, as one can have a newspaper in the house, but it's not what is happening. I don't know, Madam Speaker, how I'm going to get the legit answers that I wanted for this particular question to the Ministry of Education.
So the member is indicating that she is not satisfied by the response. So I give it back to you.
Thank you, Chair. This is the response given by the Principal Secretary, and obviously we will communicate back that the member is not satisfied with the answer, and that from her response, follow-up response, she's also indicating that if there is need of knowing those specific schools which have grievances, then we'll make a point of, as a committee, indulging her and getting to know those schools. I think that is the communication I'll take back to the committee and by extension to the ministry.
Honorable Donya.
If I'm not wrong, Madam Speaker, the member who was reading the answers is a parent. Please, if I could ask, were you satisfied with what you are presenting?
Well, Honorable Member for Kisii,
you see, Madam
I would
Speaker,
like to protect the Honorable Harrow. First of all, he's reading on behalf of the chair. The chair is not in the house. and you have indicated that you are not satisfied by this answer. So, and there is something that you said. You said the answer is on policy. And I would like, because everything is on record in this House, I would like you to register to the chair of this committee that the member for Kisii County, the Honorable Donya, is not satisfied. And now I would like to give you an opportunity to give us an indication of when you are going to give the answer that is more satisfactory, so that you pass to the chair. How many weeks do we give you?
Thank you, Chair. I will definitely pass that message to the chair, and I think it will be fair to say, as soon as we come back from recess, I'll communicate to the chair that the response to the follow-up by Honorable Donya is required. Thank you.
Thank you. So it will be after we come back from recess, the first week. Honorable members, allow me to give a chance to the Honorable Ruku. I'm aware where the Honorable Ruku was doing very important duties for this country. So please go ahead and ask your question.
Thank you so much, Honorable Speaker, for this chance. Honorable Speaker, I rise to ask two questions to the Teacher Service Commission. One, can the Teacher Service Commission outline specific measures in place to ensure that the teacher recruitment procedures are inclusive and provide adequate affirmative action safeguards to accord teachers from marginalized groups such as barrier community opportunity for equitable employment, particularly in the ongoing recruitment, in line with the fulfillment of Article 10(2)(b), Article 27(6), and Article 8 of the Constitution. Two, can the Teacher Service Commission provide the list of teachers from marginalized groups and communities, including the barrier community, who have been marginalized and who have been recruited on account of affirmative action in the past 5 years? Honorable Speaker, I also rise to ask the Public Service Commission the following two questions. One, can the Public Service Commission provide a report on the actions that the Commission has taken to mainstream marginalized groups?
Order, Honorable Ruku. I would like to ask the Honorable Abdul Haro. Honorable Abdul Haro, please come back to your seat. The question that is being asked now concerns the Departmental Committee on Education, and you have just been speaking on behalf of the chair. So please wait, you take this question, and then you can proceed to the next business that you are going to do. Proceed, please.
Thank you, Honorable Speaker. I also rise to ask two questions to the Public Service Commission. One, can the Public Service Commission provide a report on the actions that the Commission has taken to mainstream marginalized groups and communities in public service through recruitment, placement, and promotion in line with Article 232 of the Constitution and the Public Service Values and Principles Act, Cap 185A. Two, can the Public Service Commission clarify whether there are established recruitment quotas or target for marginalized groups in the public service, and if so, provide details on the progress made in meeting these quotas and targets? I thank you, Honorable Speaker.
Thank you very much, Honorable Geoffrey Ruku. I give a chance now to these questions. The two questions are referred to the Departmental Committee on Education, and I would like to give a chance to the Honorable Abdul Haro, a member for Mandera, to tell us when the questions will be responded to.
Thank you, Honorable Chair. I think 2 weeks after we are back from recess would be
He has said, Honorable,
2 weeks?
Yes,
After we come back from recess.
Yes, that's enough.
Very good.
Thank you, Honorable Speaker. Thank you.
Thank you. Next order.
Order number 11, motion, consideration of mediated version of the Water Amendment Bill, National Assembly Bill number 33 of 2023.
Chairperson.
Thank you, Honorable Speaker. Honorable Speaker, pursuant to the provisions of Article 113, subsection 2 of the Constitution, and the Standing Order 153, this House adopts the report of mediation on the Water Amendment Bill, the National Assembly Bill number 33 of 2023, laid on the table of the House on Tuesday, 15 October 2024, and approves the mediated version of Water Amendment Bill, National Assembly Bill number 33 of 2023. Honorable Speaker, the Water Amendment Bill, the National Assembly Bill number 33 of 2023 was published in July 4, 2023 and read for the first time in 26th July of 2023. The bill was considered by the National Assembly and passed with amendments on 23rd August 2023 and thereafter referred to the Senate for consideration in accordance with the Article 110, subsection 4 of our Constitution. Honorable Speaker, pursuant to the Standing Orders 144, the National Assembly Standing Orders, and the Article 110, subsection 4 of the Constitution, the bill was forwarded for consideration by the Senate. The Senate considered the bill in accordance with the Senate Standing Orders and the Constitution and passed the bill with amendments on 2nd March 2024. Honorable Speaker, subsequently the National Assembly considered and rejected some of the Senate's amendment to the bill on 30th April 2024. Consequently, pursuant to the articles of 112, Section 1, subsection B,
office by impeachment of His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, Legal Counsel for the Deputy President, Mr. Ndegonjiru, Learned Counsel, raised a preliminary objection on the legal representation for the National Assembly. Learned Counsel opposed the appearance of Honorable James Orengo, Senior Counsel, who is the serving governor of Siaya County and therefore a state officer. Learned Counsel submitted that the Honorable James Orengo is a full-time serving state officer, as per Article 260 of the Constitution, as read together with Section 26, subsection 2 of the Leadership and Integrity Act, which bars a full-time state officer from engaging in any other gainful employment. Counsel further submitted that it would be prejudicial to the Deputy President if the Senate allowed Honorable James Orengo to represent the National Assembly in these proceedings. Counsel drew the attention of the Senate to the precedent set in the matter of the proposed impeachment of the Deputy Governor of Kisii County, Honorable Richard Monda, in which a decision was taken to bar Honorable Sylvanus Osoro, Majority Whip of the National Assembly and Member of Assembly for South Mugirango in Kisii County, from appearing as counsel for the Kisii County Assembly. In his submission, Counsel cited Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act, as well as the decision of the High Court in Office of the Director of Public Prosecutions versus Orengo, Manduko, and two others, interested parties, Constitutional Petition 204 of 2019-2021, KHC 456 KLR 27 April of 2021, where Honorable Justice Ogola found and ruled that the continued representation of the first interested party, Mr. Manduku, by the respondent, Honorable James Orengo, as then was, or any other state officer is against the spirit of Chapter 6 of the Constitution for failing to conform to the mandatory provisions of the Leadership and Integrity Act. The judge ruled that in that case, there was an inescapable conclusion of conflict of interests in Senator Orengo representing the petitioner, highlighted by the fact that the interested party, Mr. Manduku, the managing director of KPA, one time be summoned to appear before a committee of the Senate to answer to some of the matters that the petitioner was being investigated on. In response, Mr. Eric Gumbo, Learned Counsel for the National Assembly, submitted that Article 77 of the Constitution is the primary law that restricts activities of state officers, and it specifically prohibits a state officer from engaging in any other gainful employment. Counsel further relied on Section 26 of the Leadership Integrity Act, which he submitted has defined gainful employment, and in this matter no evidence had been laid that the Honorable James Orengo was participating in gainful employment. Counsel referred the Senate to the decision of the High Court in Busia Election Petition number 3 of 2013, where the court interpreted Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act 2012. Counsel also cited the decision of the court in the Mwilu case, which defined conflict as where one is confronted by two different interests, where one is competing with the other. Learned Counsel for the National Assembly submitted further that no prejudice has been demonstrated that would arise or be occasioned to the Deputy President by the participation of Honorable James Orengo in these proceedings. Learned Counsel for the National Assembly sought to distinguish the decision by Honorable Justice Ogola in the Office of the Director of Public Prosecution versus Orengo on the basis that this case turned on the fact that Honorable James Orengo was at that time a sitting senator before whom the matters in respect of which his client was charged could potentially come for adjudication in the Senate, and that no possibility exists into the current matter with Honorable James Orengo as the governor of Siaya County. In his rejoinder, Mr. Njiru, Learned Counsel, submitted that Honorable Orengo is the serving governor of Siaya County and therefore a full-time state officer, and by that fact alone is a violation of Article 77 of the Constitution. Further, Mr. Njiru submitted that prejudice is not one of the applicable tests under Article 77 and Section 26 of the Leadership and Integrity Act, but that the only applicable test is whether or not Honorable Orengo is engaged in gainful employment. He argued that the National Assembly had not proved that Senator Orengo was providing pro bono services in this matter. Honorable Senators, Article 77(1) of the Constitution provides that a full-time state officer shall not participate in any other gainful employment. Further, Section 26 of the Leadership and Integrity Act provides that a full-time state officer shall not participate in any other gainful employment, while Section 26(2) defines gainful employment as work that a person can pursue and perform for money or other form of compensation or remuneration which is inherently incompatible with the responsibility of the state office, or which results in the impairment of the judgment of the state officer in the execution of the function of the state office, or results in conflict of interest in terms of Section 16. Having considered the matter, it is important to state that a state officer must inspire confidence. However, it is trite law that he who asserts must prove. In this regard, I wish to observe that the Learned Counsel for the Deputy President did not adduce evidence to prove indeed and demonstrate that the allegation of gainful employment. In fact, it is somewhat surprising that Counsel attempted to shift the onus of proving gainful employment to the National Assembly. That argument is untenable. As to the ruling of the Senate that barred Honorable Osoro from appearing for the County Assembly of Kisii in the impeachment proceeding of the Deputy Governor of Kisii County Government, it is clear that what was objectionable was that Honorable Osoro was not only a member of Parliament for a constituency in the same county whose Deputy Governor's impeachment was an issue, but also a high-ranking member of the leadership of the National Assembly, and by extension of the same Parliament before which the impeachment was being undertaken. It was ruled that in these circumstances, it was clear that in the minds of the public, the fine distinctions of the bicameral Parliament would be lost, and their confidence in the impeachment process would entirely be undermined. In the same breath, as rightfully contended by Counsel for the Deputy President, it is true that in both Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act, no test of prejudice is expressly provided for. It therefore follows that both the contention of the counsel for the Deputy President that his side will be prejudiced by the appearance of Senior Counsel James Orengo and the rebuttal by the National Assembly that no prejudice will be occasions are moot. Honorable Senators, ladies and gentlemen, having analyzed the preliminary objection raised and for the reason I have given, the preliminary objection raised on the appearance for the National Assembly by Senior Counsel James Orengo is hereby dismissed. We will now hear the response on the second objection raised by the counsel for the Deputy President. Counsel, you have 5 minutes to do that.
Thank you very much, Mr. Speaker, sir. I'll endeavor to respond to the preliminary objection within the time allowed to us. Mr. Speaker, sir, the objection was premised on Rule 20 governing the proceedings that are currently before this House. The rule reads that in presenting its evidence, the Assembly shall not introduce any new evidence that was not a part of the allegations against the President by the National Assembly as forwarded by the Speaker to the National Assembly to the Speaker of the Senate. Mr. Speaker, sir, the context of this rule is important. A true reading of this rule would indicate or would mean that every material that was available before the National Assembly while deliberating the motion that was before it is what is contemplated to have been sent to the Speaker of the Senate. The question, therefore, that we'll be asking ourselves this afternoon is whether there's any new evidence that has been adduced by the National Assembly. Our answer to that, Mr. Speaker, sir, is an emphatic no. And why do we say no? We say no for the first reason that the reference to the letter forwarding the material that came from the National Assembly contained, amongst other items, paragraph 21, which spoke to a report of a public participation that was conducted by the National Assembly. Mr. Speaker, sir, that report was tabled on the floor of the House, was adopted by the House. Deliberations in relation to that report were made. Not a single objection arose. It certainly follows, therefore, that that material from public participation became a necessary part of the material that was considered before the National Assembly. To give it context, Mr. Speaker, sir, in addition to the material that was presented by the mover of the motion to the National Assembly, the honorable members of the National Assembly had their deliberations, which also captured in the Hansard. In that Hansard, material was introduced by way of questions, by way of contribution from the floor of the House. That material, too, forms part of the evidence of the proceedings before the National Assembly. It therefore is our submission that just in the same manner in which the Hansard from the National Assembly forms part of the report that was presented before you, the report on the public participation, too, is an important component of that report. There must have been a reason why that public participation was conducted. In our humble submission, Mr. Speaker, sir, the appropriate test that one would want to apply on whether or not to allow that material to be before this honorable House is the all-celebrated test of relevance. Mr. Speaker, sir, it should not be lost that sitting as this House is sitting this afternoon, it is a quasi-judicial proceeding. It is a proceeding that is also inquisitorial. And so therefore, what is important is that the material that is presented by way of public participation or by any other way is relevant to help the House determine the truth or otherwise of the issues that have been raised for the consideration of this House. How then, Mr. Speaker, sir, do we get to answer that question? Mr. Speaker, sir, I've had a look at the specific document that my learned friend, Mr. Njiru, objected to. And Mr. Speaker, sir, It is an affidavit by one Mr. Peterson Njomo Mushira. Mr. Speaker, sir, Mr. Njomo Mushira says that he followed the proceedings before the National Assembly. He says in particular at his paragraph 4 that he has also had occasion to look at the response filed by His Excellency, the Deputy President of the Republic of Kenya, at part 1.1 of his response. And he says that he has personal knowledge of the items that were contained or that would give clarity to part of the assertions in response by His Excellency, the Deputy President. Mr. Speaker, sir, for context, that part 1.1 is contained in volume 6 of one of the volumes that were presented before you. It is the volume speaking to the response by His Excellency, the Deputy President. At part 1.1, Mr. Speaker, sir, it speaks about a hotel called the Olive Garden Hotel. In particular, at part 1.1.4, His Excellency, the Deputy President, says, in accordance with his instructions, the hotel was sold by executors to a third party. Mr. Peterson Njomo Mushira, on the other hand, says, I have information that could help.
Counsel for the National Assembly, 1 minute.
Thank you very much, Mr. Speaker. Mr. Peterson Njomo, Mr. Speaker, sir, then says that he has information which indicates that number one is a shareholder to the company which bought that hotel, and that according to him, Mr. Speaker, sir, he got into a secret transaction with His Excellency, the Deputy President, to buy that hotel. Mr. Speaker, sir, it is our submission that that is material that is relevant for purposes of consideration of the matter that is before this House. Mr. Speaker, sir, I urge that that objection be dismissed. I'm most obliged.
Thank you. Honorable Senators, ladies and gentlemen, we need not take a break to allow me prepare my ruling. Just give me a minute. I put my thoughts together so that we make progress.
Mr. Speaker, sir, with your kind permission, I was just seeking your guidance whether I need to do a rejoinder because I'm the one who had moved the assembly in respect to the...
Very well. You may go ahead as I put my thoughts together.
Thank you very kindly, Mr. Speaker, sir. In response to what my learned friend has raised, the application or the objection had nothing to do with the public participation as cited. We simply raised an objection that goes to the roots of the ability to enjoy proceedings that will appear fair to all parties. My objection was premised on the non-derogable right to a fair hearing. Council has addressed you that the deponent of that affidavit, one Jomo, was responding to the Deputy President's response. There's nothing that can be far from the truth. And this is a witness who is being brought to panel beat or to attempt to panel beat the case for the National Assembly. The question and the test, Mr. Speaker, sir, is, shall we suffer prejudice? Shall our rights be deemed to have been held? And that is the non-derogable right to a fair hearing. This is not a witness who was before the National Assembly. Where is the source of this information in the document that was submitted to this House by the Speaker of the National Assembly? Where does it sit? Who sits to suffer prejudice if the same is admitted? Is it a state organ or an individual in the name of the Deputy President of the Republic of Kenya. We urge you to uphold our ruling and justice be seen to be done, even to the people following these proceedings. I am most obliged.
Now, Honorable Senators, the second preliminary objection raised by the Council for the Deputy President was that the following documents which were submitted by the National Assembly on Monday the 14th of October 2024 were not part of the bundle of documents of the National Assembly that was served on the Deputy President on Wednesday the 9th of October 2024. These are an affidavit sworn by Mr. Peterson Jomo Mushira, and B, the document of the National Assembly marked as Volume 8A, responses from various government agencies. Counsel for the Deputy President stated that these documents prejudiced the Deputy President's case and amounted to a trial by ambush by the National Assembly. Counsel urged the Senate to bar the introduction of these two documents as they constitute new evidence in terms of Rule 20 of Part 1 of the second schedule to the Senate Standing Orders. Counsel for the National Assembly opposed the preliminary objection raised by the Counsel for the Deputy President. Honorable Senators, ladies and gentlemen, Rule 20 of Part 1 of the second schedule to the Senate Standing Orders provides, and I quote, "In presenting its evidence, the Assembly shall not introduce any new evidence that was not part of the allegations against the President by the National Assembly, as forwarded by the Speaker of the National Assembly to the Speaker of the Senate." As I indicated in my earlier communication, by a letter dated 8th of October 2024, I received a bundle of documents and records of proceedings in the National Assembly in this matter. Thereafter, on the 9th of October 2024, pursuant to Rule 6 and 7 of Part 1 of the second schedule to the Senate Standing Orders, the Office of the Clerk of the Senate sent invitations to appear to both parties. The parties were required, amongst other things, to specify any other evidence to be relied on this matter. I will repeat that. The parties were required, amongst other things, to specify any other evidence to be relied on in this matter. In response to this invitation, on Monday, 14th of October 2024, the National Assembly filed further documentation. Having analyzed the documentation submitted against the grounds for the proposed impeachment, I find that the documents objected to constitute evidence in support of the allegations already made in the impeachment motion as received from the National Assembly. It is noteworthy that the parties were instructed when sending responses to indicate any other evidence to be relied on. Accordingly, the documents being referred to do not constitute new evidence, but form evidence in support of an allegation which was already made. That is why Rules 6 and 7 of the Rules of Procedure permit the Senate to receive witness statements, list of witnesses to be invited by and any other evidence to buttress an allegation already made. What is not allowed is to introduce new allegations or to introduce any evidence that is extraneous to the allegations made in an impeachment motion. In the event, it is my considered view that the affidavit and document marked as Volume 8A being referred to fall within the permissible documents of our Rules of Procedure. I therefore rule that the objection is hereby dismissed. Now, Honorable Senators, having dispensed with the preliminary matters in this particular hearing, we will now move to hear the Counsel for the National Assembly.
Mr. Speaker, sir, with your very kind permission and indulgence, we as well, on the part of the National Assembly, had two quick preliminary issues which we wanted to draw your attention to, Mr. Speaker, sir. They are quick housekeeping issues. If you permit me just in 2 minutes, I may be able to draw them to your attention.
Exactly 2 minutes.
Most obliged, Mr. Speaker, sir. Mr. Speaker, sir, the first one is in relation to the bundle of documents that we have filed before this House to help it determine the matter that is before it. In particular, we have one of our documents, or one of our volumes, Volume 4, as a document presented before this court, before this Honorable House. Mr. Speaker, sir, when we were perusing our documents earlier today, actually yesterday, we did realize that one of the documents in that Volume 4, running from page 135 to 140, appears to have been inadvertently copied just on one part. In other words, in the course of a printing, we missed out the even numbers and just printed out the odd numbers. Mr. Speaker, sir, we have since availed that document. It is not a new document. The only thing that had happened is that we forgot, or rather inadvertently, we didn't get the even numbers printed. We have since done that, Mr. Speaker, sir, and with your permission, we urge that we be allowed to rely on that document. We filed it, Mr. Speaker, sir, and served it to our colleagues, counsel appearing before His Excellency, the Deputy President, as well as to the House, that it may be relied upon. That is the first preliminary intervention that we seek. Mr. Speaker, sir, the second issue is in relation to a letter that we did to yourself on the 14th of October 2024, wherein we sought the help of this House through your office to have summons issued to the CEO of the Ethics and Anti-Corruption Commission for purposes of helping give testimony to matters that are before this House. Mr. Speaker, sir, the reason for us seeking this preliminary intervention is to ask formally that those summons, Mr. Speaker, sir, be issued so that the said witness could attend to help us determine the matters that are before you. We, in our letter, did indicate the specific item that is to testify to, and it is equally our humble plea that an order be made that summons do issue to have the CEO of the Ethics and Anti-Corruption Commission attend as a witness. I am most obliged, Mr. Speaker, sir.
Counsel for the Deputy President, what say you?
Mheshimiwa Speaker, Honorable Senators, with regard to the first request, which I understand to mean that when they were photocopying, some pages were left, we are going to examine that and see what was served on us and what those pages that are now being introduced contain. With regard to summons to ask individuals from the Anti-Corruption Commission to come and give evidence, Mheshimiwa Speaker, honorable members, we draw your attention to Article 50 of the Constitution, which is a fulcrum of a fair trial. And this honorable House is executing a quasi-judicial function of the most weighty nature regarding the removal from office of the Deputy President of the Republic of Kenya, elected by the people of Kenya. Nothing would be more prejudicial than to call witnesses whose statements or affidavits we have not seen. The whole purpose of affidavits and witness statements is to enable the other side, in this case, the Deputy President, to seek legal advice, to give instructions on how best to respond to it. And this Honorable House has fixed 2 days for this trial. And one of the issues we'll be raising is these allegations, and you are going to go through them, against the Deputy President, suspicions, conclusions, on matters that were never referred to DCI in Kiambu Road, who are trained to investigate these matters. Nothing was referred to the Anti-Corruption Commission or any of the other investigative agencies, including money laundering. We strongly object and ask that the record of this Honorable House reflects that if this is permitted for the National Assembly to call witnesses at this stage without first furnishing us with their witness statement and affidavits, the case of the Deputy President will be irredeemably prejudiced. So we object very strongly to that application.
Counsel for National Assembly.
Mr. Speaker, sir, in brief rejoinder to the objection by learned senior counsel for the Deputy President. Mr. Speaker, sir, in the invitation to attend that was extended by this House to the National Assembly, the invitation included a request as to a list of witnesses the National Assembly required summoned. We responded to that request, and Mr. Speaker, sir, all we seek is a confirmation that our response has been actioned. What the learned counsel for the Deputy President is objecting to is not our request, but really it is a response to a request made by this august House. I'm most obliged.
Counsel for Deputy President, do I get it that you have no problem with the first request made by the National Assembly?
Mheshimiwa Speaker, we would want to see those pages. And that time we'll be able to say yes or no. It is the second one.
Clerk, has that document been made available to the Deputy President's team? Kindly, in the next few seconds, make it available so that we make progress. Honorable Senators, if there's any senator who has not gotten that document, you may also let the chair know so that we supply you with that document. Senator Mazayo, Senator Olekina, Senator Miraj, Senator Kavindu, Crystal Asige, Senator Kajwang.
Honorable Speaker, if I may, with your permission, just to highlight one point based on what my learned friends for the National Assembly have said. The letter they refer to is a letter dated the 14th of October 2024. It is addressed to the Honorable Speaker of the Senate by the Clerk of the National Assembly. The letter does not contain any information about any other witnesses being sought. It does not indicate that the Ethics and Anti-Corruption Commission will be asked to produce any other witness, affidavits, or documents. Thank you very much.
Mr. Speaker, sir, if I may.
Just take your seat for a minute. Senior Counsel Paul Mwite, are you in receipt of the document now?
Mheshimiwa Speaker, this document, we are seeing it for the first time now, 3-4 minutes ago. And it has got many, many pages, so we were quickly going through it, and in order to save the time of this honorable House, perhaps you can give us an opportunity to go through these documents, because we need to go through them. Inaonekana kama hii ni ukarabati, but let's go through it. Perhaps if you agree, Mheshimiwa Speaker, perhaps we can get on with the first prosecution witness giving evidence, and as soon as we've gone through this, then we shall come back to you, Mheshimiwa Speaker.
Thank you for your wisdom, Senior Counsel. Now, the other name that has been raised is on the issue of summons to witnesses. Now, if you look at our rules of procedure, more particularly rule number 10, which provide as follows, that the Senate may, at the request of the National Assembly or the President, and in this particular matter, the Deputy President, invite or summon any person to appear and give evidence before the Senate. So the summons that have been sought are in line with the spirit of Rule 10 of our Rules of Procedure. You may attack the evidence when these particular witnesses who have been summoned, if their evidence introduces other allegations, then at that particular juncture, the legal team from the Deputy President, you may raise an issue, and I'll certainly hear you at that juncture.
Permit me, Mheshimiwa Speaker, to place it on record that the rules of this Honorable Senate must and have to be respected. But even above respecting the rules of this Honorable House, our Constitution has to be respected. Article 50, the right to a fair trial, which in terms of Article 25C, Mheshimiwa Speaker, you will remember, you are aware, that is a right that cannot be compromised in any manner. There has been no explanation why the EACC was never asked to investigate the allegations before they were tabled before the National Assembly and before a decision was taken, because the National Assembly cannot investigate criminal offenses. In fact, in implementing Chapter 6 of the Constitution, the Act of Parliament said a conviction is necessary. And now you want to reverse the will of the Kenyan people in electing the Deputy President without him being reported or the matter being investigated or him being convicted. Mheshimiwa Speaker, I plead that you reconsider your exercise of that discretion in permitting witnesses from the EACC to be called in order for the Deputy President to have a fair trial before the Senate. Thank you.
Senior Counsel Paul Mwite,
Mheshimiwa Speaker,
you're actually arguing your case. What I said, there was some invitation that was sent to both parties, and each party was requested to submit a list of witnesses. The National Assembly submitted a list of witnesses with a request under Rule 10 of our Rules Procedure for the Senate to summon. That is the request that has just been made by the National Assembly, and it is permissible and it is within our Rules of Procedure.
Mheshimiwa Speaker, you are...
Senior Counsel Paul Mwite, I will refer you to Rule number 30 of our Rules of Procedure, where the ruling of the Speaker is final. So let's leave the matter there. I've made my ruling. Let's make progress, Senior Counsel.
Mr. Speaker, I agree entirely. You are the one sitting in the seat of power. Your word is final. I have said what I've said. Your rules are subject to the Constitution. I accept your ruling.
Now we'll move to the second limb of this hearing. Honorable Clerk, you may now proceed to call the next order. Summons to issue to those witnesses.
Order number 2, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Now, honorable senators, ladies and gentlemen, we are going to move to the opening statements. Each party will have exactly half an hour to make their opening statement, starting with the Counsel for the National Assembly. Your time starts running from now.
Thank you very much, Mr. Speaker and honorable members of the Senate. Indeed, speaking for us, this is a very momentous occasion in our history and must be recorded as such. The United States of America is 248 years old since its independence. And for that entire 2.5 centuries, no Vice President of the United States has undergone a process of removal by way of impeachment. In a way, we are making history. And for me, it is such an important occasion for the 13th Parliament and this Senate that it will go down in the annals of history that the first impeachment of a deputy president in the Republic of Kenya was undertaken by this particular Senate. And we come here with a lot of confidence that the Senate is not new to the process of impeachment as understood under our Constitution. Indeed, the Senate has handled so many impeachment proceedings in relation to the offices of governors and deputy governors. And more importantly, that this Senate has been a great contributor in establishing the jurisprudence revolving around the impeachment process in the Republic of Kenya. Many of the cases that have gone for determination in our system of courts, High Court, Court of Appeal, and the Supreme Court have involved the participation of the Senate. So as we address you today, we are not addressing a chamber that is dealing with a novel idea. Indeed, by dint of Article 10 of the Constitution, which requires all state organs and state officers to make any decisions or apply the law and the Constitution, they are required to apply the Constitution of the Republic of Kenya. That is by dint of Article 1, Article 10, Sub-Article 1. So it should not be lost to anybody that the application of the Constitution in decision-making is entirely in the province of the courts. This Senate, on this particular issue, you are seized of this matter. It is an exclusive jurisdiction that is granted to the Senate to undertake a trial for the impeachment and removal of a deputy governor or our governor or deputy president or president. This is an exclusive jurisdiction that even the courts have spoken about many times. The courts can intervene in limited and justified occasions that merit their intervention. But it should never be lost that this is the trial court, if I may put it that way. And we also come here knowing that the Senate now is a repository of the law in regard to impeachment. All the cases involving the impeachment of governors and deputy governors that have gone to the court have involved the participation of the Senate. So if ever we are to talk about a repository of the law regarding removal of state officers by way of impeachment, it is the Senate. And it should not be lost historically from comparative studies of various jurisdictions why this role in our constitutional design was left to the Senate. It was a decision by the framers of our Constitution that this should be an exclusive matter to be dealt by the Senate. Having said that, I was advised by the leadership of our National Assembly, who are our clients, to read a certain passage from the Bible. I think I have a copy here. Yeah, I'm so sorry. I had to carry this particular Bible. I was so advised. And this is, I read the Bible a lot to myself, but never in this kind of occasion. And this is in the book of Exodus 22, verse 22 and 23. And I read both the St. James Version, which is the one I prefer because of the language, and from the Living Bible, which is in English is more appropriate. And I read, that is from the King James Version. Ye shall not afflict any widow or fatherless child, and my wrath shall wax hot, and I will kill you with the sword, and your wives shall be widows, and your children fatherless. From the Living Bible Version, it reads as follows. And the language is a little bit more palatable. You must not oppress, or you must not exploit widows or orphans. If you do so in any way, and they cry to me for my help, I shall surely give it, and my anger shall flame out against you, and I will kill you with enemy armies, so that your wives will be widows and your children fatherless. This is the Lord of the Old Testament. Now, I will come back to this matter later. But for now, I want to walk a constitutional journey with the Senate in giving a panoramic view of what our constitutional order is in regard to the office of the President and the Deputy President. Under the old Constitution, we had no provisions like the ones we have in this Constitution. But this Constitution, and I want to persuade the Honorable Senate, that it does not just address rights as contemplated in the Bill of Rights, but it also addresses fears. Fears out of a long struggle and experience of the people of Kenya. And in the Kenyan people having given themselves this constitution, they were addressing rights and fears, and more importantly, they wanted to establish a system of government that can work. And with that, I want to take the Senate to Article 75 of the Constitution, just to draw the attention of the House of the seriousness of what the matter we are dealing with, which is provisions in relation to oath of office of state officers. 74. Before assuming office, before assuming a state office, acting in a state office, or performing any functions of the state office, a person shall take and subscribe the oath or affirmation of office in the manner and form prescribed by the third schedule or under an act of Parliament. Mr. Speaker, I want to take you to that schedule, and I want to draw a difference, a distinction between the oath of office that is administered to the President and the Deputy President, as opposed to the other oaths that are taken by other state officers, including members of Parliament. And there's a big distinction. And when it comes to the oath of the due execution of office for the President and that of the Deputy President, which is found in the third schedule of the Constitution, there are words there that I would plead to the Senate to consider in consideration to the matters which are raised in the motion of impeachment by the National Assembly and the charges as they've been read out here. Now, the motion, the oath for, or solemn affirmation for due execution of office for the Deputy President reads as follows. I do swear solemnly affirm that I will always truly and diligently serve the people and the Republic of Kenya in the office of the Deputy President. I pause there to emphasize those words that are found in the Constitution, that I will always truly and diligently serve the people of Kenya, that is the Republic of Kenya. And it continues to say as follows, that I will diligently discharge my duties and perform my function in the said office to the best of my judgment, that I will at all times, when so required, faithfully and truly give my counsel and advice to the President of the Republic of Kenya, and that I will do justice to all without fear. I emphasize the word doing justice to all. Those three words in the oaths and affirmations for due execution of office, which are found in the third schedule, are not contained in similar words when it comes to the Speaker of the Senate, the Speaker of the National Assembly, the Chief Justice. It only applies to the Deputy President and the President. Why am I saying this? Because if you look at the Constitution in terms of the election of the President and and the Deputy President, you'll find that, Mr. Speaker, sir, that the President and the Deputy President are elected at constituencies. And in that election, they must receive a majority of votes in at least half the constituencies in the Republic of Kenya. What I'm trying to say, it has come out, and I say this with utmost respect, that the Deputy President who stands here on trial by the Senate would assume that he was elected to represent the interests of a certain region. Whereas the Constitution is clear, he's elected by the whole country. He's got no area to protect. Under the old Constitution, the President had to be elected from a constituency, a Vice President had to be elected from a constituency as a Member of Parliament. This Constitution has no similar provisions. And now when you come to the functions of the Deputy President, and I think this is extremely important in the kind of relationship that there should be between the President and the Deputy President, it says so in the following words, which I need to read for clarity in terms of the Deputy President. And those are found in Article 147, that he shall be the principal assistant, deputized for the President in execution of the President functions, and also he may be assigned duties by the President. The kind of symbiotic relationship that should exist between the President and the Deputy President is underlined in this Constitution. Now, it is uncontestable, and I think this is the issue that I want to deal with in some detail. It is uncontestable from the record that you have, even from the Deputy President, that the words he is accused to have uttered, where he alleges that Kenya is like a company existing of shareholders, that does not sit with the Constitution of the Republic of Kenya. Kenya is not a republic that is established on the basis of shareholding. It's a republic of citizens. So when a Deputy President talks about taking the interest of Watu Murima, for whatever that would mean, it is not in compliance with his constitutional remit. And the words are there. What he has said in public on this issue is very clear. The second issue is on the question of collective responsibility. You would find out from this Constitution that in nearly all the important constitutional bodies established under the Constitution, the Deputy President is a member of those particular institutions or organs, like the National Security Council. So one would wonder where even the issue of the Director of Intelligence would be discussed in a public forum by the Deputy President when he is the second in command in the National Security Intelligence as established under the Constitution. So I would want, and I plead with the Senate, look at the utterances of the Deputy President vis-a-vis his role under the Constitution. And he has even said that where he has said certain things that are deemed to be insightful, that is protected speech. It cannot be protected speech under our Constitution, because under Article 33 of the Constitution, because of what we have undergone as a nation, Article 33, sub-article 2, has a limitation that the expressions that extend to propaganda for war, incitement to violence, hate speech, advocacy of hatred, that cannot be protected speech. Now, the other very important point which I want to put before the Senate, sometime in February 2017, the Deputy President traveled to London, and he went to a hospital in London where his brother was admitted in ICU. When he arrived the next day, he prevailed upon his brother to execute a will. That was on the 17th of February, 2017. In that trip, there is no evidence at all that he tried to talk to doctors or physicians who are looking after his own brother. After those visits, he walked away. And 7 days later...
Mr. Speaker, I rise to raise an objection.
Can I proceed?
Mr. Speaker, we owe the Deputy President very elementary decency. We owe it to the Deputy President to be basically decent in these proceedings. I want to know whether counsel at the bar, one, can adduce this kind of evidence that is not contained in any evidentiary material before the Senate. I want to know which ground in the 11 grounds in the impeachment motion is this evidence from the bar supporting. I repeat, Mr. Speaker, we owe the Deputy President the most basic decency. I object.
Senior Counsel Orengo, those amendments, are they contained?
They are contained, they're all here.
And refer to the document.
Volume 4. I am not referring, because if I've got to refer to every document, will take a lot of time, and I have only 30 minutes. If you look at volume 4 of this document on public participation, from page
Volume 4 of the National Assembly.
Of the National Assembly.
Pages?
Pages 114 to...
In fact, it is the Deputy President who has also relied on that will. It's also part of his defense.
Yes. And in fact, this page is also called Tend the Will. And the Deputy President is the one who is relying on this will. The death certificate is contained on page 119. And it shows the only person who attended the deceased, the brother of the Deputy President at that time, was his daughter, was the only person present. And then there's the will, and in the document on page 128, and this is why I was raising this matter, on page 128, there's a letter by Mr. Madenge and Mr. Njoroge Rigeru, who together with Mr. Rigathi Gachagua were the joint will executors. And they're complaining about the conduct and action of the Deputy President as an executor of the will and a family member of the late Nderitu Gachagua. On page 129, paragraph 8, there, and it says, from bank statements to this, for this account seen by us, you transferred some funds from these accounts to other persons as follows. On the date when Nderitu Gachagua died on the 24th, the Deputy President was already withdrawing money. On the day he died, and that day when he died, he was there only with his daughter. And then they say on the 19th of May 2017, again another money was withdrawn and paid to Mrs. Wamunyuro Investment Limited. This story, you will find it in the documentation. And part of it is what Mr. Njomo was saying.
Counsel for Deputy President, just have your seat. When your time comes, you'll be able to make the rebuttals. Proceed, Senior Counsel.
How many minutes do I have?
Mr. Speaker, I respect your direction. I'm willing to take a seat right away, but just to point out something. The document you are being referred to is the document you held in abeyance. Because it was given to us later for purposes of our consideration. That's number one. Number two, Mr. Speaker, you remember that my learned colleague talked about how my client traveled to London, how without talking to any doctor. These are factual claims, Mr. Speaker, that are just coming from the bar. Mr. Speaker, number three, the opening statement speaks to the motion and the grounds in the motion. I beseech this House direct that parties restrict themselves to the motion and the grounds in the motion. The facts you are now being referred to have no basis in the motion and the grounds in the motion, unless Senior Counsel, His Excellency Governor Rengo, can draw your attention to any ground in the motion that those facts are now addressing. I repeat what I said earlier, Mr. Speaker. The ruling is yours. We owe it to the Deputy President and the integrity of our check and balances institutions to maintain basic decency in these proceedings. I rest.
In fact,
Counsel, I cannot tell you how you're going to make your opening statements. If you're going outside the allegations, that's up to you. The senators are here listening, and they'll be able to make the necessary decision at the end of it. Now, Senior Counsel Orengo, there's an averment that you've made that the Deputy President of the Republic of Kenya, on a certain date that you indicated, traveled to London.
Yes. The evidence is
his sick brother.
Yes.
And on the side of the sick bed, he made his brother sign a will. Is that contained anywhere in the documents from the National Assembly?
My Lord, Mr. Speaker, if you look at volume 4 from the pages that I indicated, right from page 113, it shows what flight he took at what time a British Airways flight on the 16th and arrived in London on the 17th. The only business that comes out from that document and his documents is that he got a will signed, and there is no further evidence of his activities in London until 24th, when the only activity in which he didn't participate was to be present when his brother died in London. But all this I'm saying in relation to the allegations that we have against the Deputy President.
Mr. Speaker, sir. Council, ordinarily, no objections are raised during the 30 minutes of the opening statement. Ordinarily. I have tried to accommodate, but now you're stretching my generosity a bit too far. Allow Senior Counsel Orengo to conclude. In your opening statement, you may choose to make a rejoinder.
What I want to conclude is this. From what I've said, from the way his brother's account were raided, that was continued to the time when All Life Guidance was acquired for a sale by proxy of 412 million shillings. He bought a property in Nyeri, the outspan and treetops for an amount exceeding 800 million shillings. And we're saying part of that money was not money coming from him, and evidence will show that he was raiding monies that truly belonged to the estate of his late brother to acquire property. If that is not an offense by law, these were proceeds of crime committed by the Deputy President to acquire property. And to drive this point home, the judgment by Justice Minor, which is also part of the record, where she made a determination, and that judgment stands, that the 200 million shillings that was found in an account with a financial institution in excess of 200 million shillings were proceeds of crime. And that 200 million shillings, again, the documentation here, if you look at it and we show it in evidence, was the same money that was used to acquire treetops and Aberdares as part of the money that his sons were able to use to acquire those properties. So we are saying that the acquisition of these properties came out of criminal conduct, and all the particulars of the criminal conduct is found in the documents that were presented before the Senate. Now, Mr. Speaker, I think that it is critical that we look at the authority of the office of the Deputy President vis-a-vis that of the President, the doctrine of collective responsibility. And I showed why the office of the Deputy President is so important in carrying certain functions so long as he lives to the true spirit of the Constitution. Many times, and the incidents have been shown, acts of insubordination, like when he issued a press statement in Mombasa after the President himself had issued a statement that went contrary, absolute insubordination to the President, who is his boss. And if really one can talk about insubordination, that was an act of insubordination. Lastly, the other issue that I need to bring out quickly is that the Constitution and the Senate is aware of the fact that at the end of, at every 5 years, you pass a basis for allocation of resources here in the Senate. And they abide by certain principles which are contained in Article 203 of the Constitution. This issue about certain areas being preferred because they're shareholders goes against the very spirit of the Constitution. Or the notion that people can be appointed into government on the basis of how they voted or on the basis that they are shareholders, that is not again borne by the Constitution, because the executive authority that is granted to the executive requires that even in allocation of revenue and appointment of people to serve in the public service must depend on regional balance. So to talk about shareholders, to talk about some people being able to reap on the basis of shareholding, that is repugnant and in conflict with the provisions in our Constitution. Now, Mr. Speaker, I would want to say this with all the seriousness it deserves. This Constitution is supposed to work. It's supposed to work. And it can only work if state officers are compliant with the provisions of the Constitution.
2 minutes to wind up.
Yeah. Well, if they're compliant with the provisions of the Constitution. The doctrine of collective responsibility and the authority of members of the cabinet spring from the fact that they are all individually and collectively responsible to the president. If that primary principle cannot be applied, then it will be difficult for any government elected to function in a manner that it can deliver services to the people of the Republic of Kenya. So I urge this Honorable Senate that having painted that large picture, the next phase, when you are now going to listen to the evidence and look at the exhibits that we have attached, you'll find that a strong case has been made out for the impeachment and removal from office of the Deputy President of the Republic of Kenya. And this Senate should not shy away from undertaking that responsibility. It does not matter that there is a matter that could be taken to DCI or to the AACC. The role of Senate is different to undertake oversight over those who are given a responsibility to manage the affairs of the country. And that does not depend on the role of any other agency or body created by the Constitution. Your role is to demonstrate to all people in state offices that this oversight role that you play, whether it is that of impeachment, to demonstrate to the people of Kenya that it is not cosmetic. And where there's evidence, like the evidence that we are showing and adducing before you, that person...
I'm afraid, Senior Counsel, your time is up.
...should suffer the consequence. I thank you. I thank you.
Counsel for the Deputy President. The floor is yours.
Thank you, Mr. Speaker, sir, and thank you, distinguished senators. My name is Elisha Ongoya. I stand here to make the Deputy President's opening statement. Allow me, Mr. Speaker, sir, distinguished senators, to open by reminding us some fundamental principles. We are sitting here today as a Senate to discharge a constitutional mandate. And before you are given the cudgels to start discharging any mandate in this Senate, the Constitution demanded that you had to take an oath of office before you do anything else. I now understand better why that oath of office was prescribed and why it was framed the way it was framed. The Deputy President reminds you the following terms in your oath of office before you assumed office to discharge the functions of senators. You have to bear true faith, and allegiance to the people and the Republic of Kenya. You have to obey, respect, uphold, preserve, protect, and defend the Constitution of Kenya. And you have to faithfully and conscientiously discharge your duties as members of the Senate. I submit respectfully that the case regarding the proposal to remove the Deputy President from office by impeachment may appear to put the Deputy President on trial, but that is only in the most technical sense of this process. At a more significant level, what is on trial throughout these proceedings is the resilience and steadfastness of our Constitution, our constitutional institutions of checks and balances, and actually their capacity to withstand any form of waves and pressures. That is what is truly on trial. His Excellency Rigathi Gachagua beseeches this House to keep in mind that we have a constitution, a constitutional order, and a constitutional democracy to protect as we conduct these proceedings and as we make decisions in these proceedings. He asks you that at the end of this exercise, let our constitution, our constitutional democracy, and our constitutional order emerge stronger. Allow me to address this House on the defined standard for impeachment of the Deputy President. In a comparable decision by the Supreme Court of Kenya, the case of Honorable Mike Mbuvi Sonko versus the Clerk, County Assembly of Nairobi and others, the Supreme Court observed as follows, and I quote, "It must, however, be stressed for the avoidance of doubt that the power of impeachment, removal, or recall is not one expected to be in constant or frequent exercise. It is only in the face of credible evidence of extraordinary wrongdoing that the conduct of a state officer will be investigated, and even then, only upon sufficient proof of the allegations that the impeachment, removal, or recall would be warranted." Two questions we pose must constantly linger in your minds, distinguished senators, as you undertake the assignment now before you. Question number one, we beseech you to bear in mind the question, is there credible evidence of extraordinary wrongdoing on the part of His Excellency Honorable Rigathi Gachagua before you? Number two, is there sufficient proof of the allegations leveled against His Excellency Rigathi Gachagua? Article 150, Clause 1, Paragraph B, sets out the grounds for removal of a deputy president from office by impeachment. These grounds are, number one, gross violation of the Constitution or any other law. We emphasize the drafter's use of the word gross. Serious reasons to believe that the deputy president has committed a crime under national or international law. Again, we emphasize the word serious, then gross misconduct. surmises, conjecture, street rumors cannot pass muster. This conduct must be the conduct of the person of the Deputy President. It is sufficiently notorious for this court to take judicial notice of when the late Rigathi Gachagua, whose will is now referred to here, died. You are told to investigate the conduct of His Excellency Rigathi Gachagua at a time, or at the time around which his brother, His Excellency Governor Rigathi Gachagua, as he then was, died. It is sufficiently notorious that His Excellency Rigathi Gachagua was not Deputy President of the Republic of Kenya. But that's not enough. You will peruse the motion before you with a view to finding which ground in that motion is sought to be established by these allegations around what may or may not have happened around the time the late Rigathi Gachagua died. You will find absolutely no ground supported by those allegations. Let me disclose here. It is designed to whip your emotions. It has no other purpose. Looking at your oath of office that I've alluded to, there is no room for your emotions to be whipped as the basis of decision making in any act that you engage into in the discharge of your constitutional mandate and responsibilities. What does our Constitution expect of the mover of the motion in proceedings of this nature? Our Constitution expects the mover of the motion to make allegations of any or all the grounds set out in Article 150, Clause 1, Paragraph B of the Constitution. And to begin by submitting, it is true that the mover of this motion has written down some allegations in Volume 1 of the documents from the National Assembly. Secondly, the mover of the motion is thereafter expected to supply credible evidence of an extraordinary wrongdoing and sufficient proof of the allegations against the Deputy President. Mr. Speaker, sir, distinguished senators, we submit that is where the mover of this motion ought to start having problems with this House when he's called upon to account. It is the submission of His Excellency Rigathi Gachagua that the motion now before you has fallen short of the threshold set by law by multiple miles. When you examine the material before you, you will discover that it will oscillate between the following categories of stages. One, you will have material before you that is just plainly false. Then from falsehood, it will go to the ridiculous ones. And I'll demonstrate that shortly. There will be ridiculous claims here. Then finally, it will end up into embarrassing claims. Allow me, in the few minutes I have, to just do a snip preview of some of these claims so that we have an overview of the case that is before you. At paragraph 74B of the first volume, which is the impeachment motion, you will find an allegation of this nature that His Excellency Rigathi Gachagua has influenced his family members, allies, associates, and proxies to take control of a local cooperative society in Madeira, which they are financially hemorrhaging. Number one, no name of any family member is supplied in the allegation or in any of the evidentiary documents before you. No name of any ally is supplied in the motion or in any of the documents before you. no name of any associate is supplied, even a false name, none, is supplied in the motion and in the documents before you. No name of any proxy is supplied in the motion or in any of the documents before you. The name of the alleged circle is not identified. You can imagine, Mr. Speaker, sir, distinguished senators, being called to defend yourself on a claim that you have taken over through your associates a circle that we don't know. Told, now come and defend yourself. I began by saying some of these claims are either ridiculous or embarrassing. Secondly, at paragraph 74A, you'll be told that His Excellency has connived with cartels in the tea sector to block the Kenya Tea Development Agency from implementing guaranteed minimum returns that would benefit tea farmers. No statement, no affidavit, no correspondence from any official of the Kenya Tea Development Agency is before you. No complaint to any agency, no complaint to this parliament by any official of the Kenya Tea Development Agency is before you. It's just a claim which the mover of this motion said before the National Assembly, and surprisingly, to those of us who have some residual faith in our institution, he told the National Assembly, just believe my word for what it is. And when we thought that was a joke, we got a joke lifted a notch higher. The National Assembly actually just believed his word for what it is. No evidence. Nothing in the affidavits before you addresses anything about the Kenya Tea Development Agency. Nothing in the 5 affidavits before you. Let's progress, good people. Paragraph 72 of the motion before you states that His Excellency has persistently undermined, demeaned, and committed insubordination instead of assisting the President. And let's face it, Mr. Speaker, sir, distinguished senators, if you accuse somebody of insubordination, the only person who can complain of being insubordinated is the supervisor. No statement from the President, no affidavit from the President, even no witness summons to the President has been sought here. To call him to complain, he has been insubordinated. The Deputy President, when he received this motion, wrote to the Secretary to the Cabinet, requesting to be supplied by all assignments given to him by the President and any that he has not delivered. To date, as we stand here, we have not received a response to that letter. And yet we shall be told, just believe the mover of this motion, the Member of Parliament for Kibwezi West constituency, that when he is oscillating between the National Assembly and Kibwezi West to serve his people, he knows better than the supervisor of the Deputy President that the Deputy President has insubordinated his boss. I began by observing they will move from the false through the ridiculous to the embarrassing, and these are the claims before you. At paragraph 64, paragraph A of the impeachment motion, you will be told that His Excellency, the Deputy President, said that he would present a petition for the removal of Justice Esther Maina from office, which he has not done to date. Mr. Speaker, sir, my eyes are normally problematic, so I will not know the time allocation.
15 minutes.
Thank you so much, Mr. Speaker, sir. The claim is that His Excellency publicly said that he would present a petition for the removal of Justice Esther Maina from office, which he has not done to date. That's the complaint. Evidence is before you that there is a pending complaint by His Excellency, the Deputy President, before the Judicial Service Commission. So the mover of this motion first has perjured himself in his affidavit by saying that each of these facts are correct, when this fact is false by evidence available. You will find that paragraph 34 of the motion before you, it says that His Excellency falsely threatened to file a petition for removal of Justice Esther Maina. How can the Deputy President be accused of falsely threatening when in fact he has filed the complaint? Where is the falsehood when there is a pending complaint? That complaint is before you in the Deputy President's documents for your own perusal. I began by saying they'll move from the false through the ridiculous to the embarrassing. At paragraph 78C, you'll be told that His Excellency routinely summons procurement officers in ministries and state institutions and instructs them to direct procurement of goods and services in a specific manner. No officer from any ministry will swear an affidavit claiming to have been summoned to award any procurement for any goods or any services in a particular manner. In fact, what you'll have before you is actually very ridiculous. You will be told that there was a tender for supply of mosquito nets that was cancelled in May 2023. Then a local company that was an agent of the supplier was following for the return of its bid bond in July, 2 months after the cancellation of the tender. How can you influence a tender that was cancelled 2 months ago? I told you it will move from the false through the ridiculous to the embarrassing. Now, the more interesting one is at paragraph 78A. You will be told that His Excellency bullied Kenya Medical Supplies Agency officials into awarding a tender for the supply of mosquito nets to Crystal Limited. Good people, Crystal Limited was not even a bidder for that tender. He pressurized people to award it to somebody who is not even a bidder for that tender. I observed it will move from the false through the ridiculous to the embarrassing. Those of us who understand this motion for what it is, understand why these panel beating maneuvers are being tried here. The motion as presented and approved by the National Assembly will remain in our constitutional history as the most embarrassing motion ever approved by a House of Parliament in the Commonwealth. We respectfully submit. You'll be told at paragraph 58 that His Excellency is reasonably suspected to be the principal beneficiary of what are called dubious transactions by Lusona Events Limited. You will then go to the allegations on Lusona Events Limited and you want to see those transactions, how are they terminating to the Deputy President? You'll not come across any connection. They'll just say, a director of this company withdrew some money from his own company, the Deputy President is a director, none of his family members are director. That person withdrew money from his company, bought a motor vehicle in his own name. The mover will say, I'm therefore drawing a reasonable conclusion that the Deputy President is the beneficiary of this. Good people, the word reasonable has meaning known to law. I submit very respectfully that this falls short of the definition of the word reasonable suspicion. I submit it actually gravitates towards unreasonable suspicion. Now let's look at this. You'll be told that His Excellency has acquired 40 acres of land in Kakuret, Kamburaini, in Nyeri. Evidence before you will show that this is land that the Deputy President, in fact, bought from a current member of the National Assembly. So he knows that member. In 2015, before he even joined state office as a member of parliament, you are told that the purchase of this land in 2015 shows that in the last 2 years, the Deputy President has amassed immense wealth. I began by saying, let's be elementarily decent. One of the most frustrating things about preparing for such a hopelessly conceptualized, hopelessly crafted, and hopelessly presented case is that you begin doubting yourself because you begin wondering, what am I not seeing? Land bought from a sitting member of the National Assembly in the year 2015 is supposed to be evidence that in the last 2 years, His Excellency Rigathi Gachagua has amassed immense wealth from the office of the President to acquire that property. Now, let's look at paragraph 45G. You'll be told that His Excellency has acquired 80 acres of land in Meru County. No land registration number is provided. Not even an affidavit of a neighbor who says, I know yes, this land is my neighbor. Just an allegation by the mover of this motion like that. And the Swahili say, ukistaajabu ya Musa utaona Firauni. This mover of this motion stood before the National Assembly and said, just believe me for this statement as it is. The first joke. The second joke, the National Assembly actually believed him and approved the motion. You'll be told that paragraph 45H, that His Excellency has acquired a dairy farm in Nyandarua County. Now, I guess we all have a common understanding of what a dairy farm is. His Excellency has no dairy farm in Nyandarua County. The move of this motion does not give us any evidence of this dairy farm in Nyandarua County. You'll be told that His Excellency has used the office of the Deputy President to corruptly influence unnecessary and expensive renovation of his official residence in Karen and Mombasa. What will shock you is this, good people. The contract for the renovation of the official residence of the Deputy President was signed by the controller of State House. Unless the move of this motion wants to make a claim that the Deputy President conspired with the State House to have this contract executed. Number two, it will be known to all of us as members of Parliament that the money for renovation of this official residence was approved by the National Assembly. Is the National Assembly conceding that it approved money for unnecessary expenditure by government? How can the National Assembly approve money for use for renovation of the residence of the Deputy President, then after that money is used for the intended purpose, the renovation of the official residence of the President, now drag the Deputy President for impeachment for the reason of that renovation? I said it will move through the ridiculous to the embarrassing. You'll be told that the Deputy President has a helicopter landing facility at his land, Ruguru, Kiamariga, 1223 in Madeira. The Deputy President simply has no helicopter landing pad on that farm, a small parcel of land with napier grass, unless the mover of this motion can now convince us that new technology has emerged, that napier grass is the constructing material for landing pads for aircraft. That's the only way it can make sense. But because it doesn't make sense, good people, you'll agree with me, it moves from the false through the ridiculous to the embarrassing. Now let's deal with it. You'll be told the Deputy President has amassed a wealth portfolio amounting to 5.2 billion shillings. Elementarily, we must then look at the particularization. Tell us which one is what plus which one is what plus which one is what to amount to this 5.2 billion. This figure, the origin, is only known to the mover of this motion. There is nothing on the body of the motion. There is nothing in the documents attached to the motion. There is nothing in the video clips to be played by the mover of this motion that tells us mathematically how he arrived at this figure of 5.2 billion shillings. Then when the charges were read, distinguished senators, you had some 22 companies being read one by one. Thank you. 22 companies. A number of things will surprise you. You'll just find a company listed called Spiritway Limited. Nothing in this motion tells us what wrong has this company done. Nothing in the motion, completely. It just listed there the way it is. Fortis Vis Group Limited. Nothing in this motion tells us what wrong has Fortis Vis Group Limited done. They're just companies whose names have been listed, and we have spent the taxpayers' money this afternoon listening to these companies' names being written with nothing in this motion telling us. So what wrong has Dorcas Rigathi Foundation done? What act are you complaining of for that company? What omission are you complaining of in respect of that company? Heartland Supplies Limited, you just find a name of a company there. No wrongdoing is alluded to it. No allegation is made against it. They're just companies thrown there. Distinguished senators, the Romans called their assembly, which was the equivalent of this Senate, the patres. It was an advisory council. That name was derived from an old Latin word meaning father. Senate derives its name from the Latin word senex, meaning old man. All these words are supposed to address the sagacious, the state of wisdom of the Senate. If this Senate lives true to its historical origin as the patres, if this Senate lives true to its Latin origins as the senex, the old man, the wise man, it will see through these lies, it will see through this ridiculousness, it will see through these embarrassing statements. If time were to permit, I will take you through other allegations that meet the same test of falsehood, ridiculousness, and embarrassment. Fortunately for us, the rules of procedure permit us to cross-examine the move of this motion and the respective witnesses as a way of bringing forth these lies much more clearly. We shall do that when the time presents itself. At the end of it all, we shall beseech you to do two things: to be true to your oath of office as senators, to be true to your oath of office as senators, to pour through this evidence, to listen keenly to this evidence, to make a decision premised on the evidence as tested here in cross-examination. And if you do that, we have no doubt in our mind, you will reach the same conclusion that what has been presented before you as a most consequential motion, perhaps in our lifetime, is false, is ridiculous, is embarrassing. I rest the governor's opening statement.
That is the Deputy President Council. It's not the governor.
My apologies, Mr. Speaker. I have been here multiple times on governors, and I think that is what was reigning in my mind. I rest the Deputy President's opening statement. My apologies for that.
Very well. Now, honorable senators, will now move to hear the case of the National Assembly. Now, the National Assembly has 3 hours to present its case, meaning all the witnesses, evidence in chief, cross-examination will be given 2 hours. The legal team for the Deputy President, you'll have 2 hours to cross-examine the witnesses as presented by the National Assembly. Clerk, you may now usher in the first witness of the National Assembly.
Mr. Speaker, as we wait for the witness, I crave, if it finds favor with you,
one of my assistants could come to help us with turning the pages, I reckon that way we would move much faster. Is called Boniface Mawira. He should be perhaps in the gallery.
That's a valid request. You may proceed. Counsel for the National Assembly, where are your witnesses coming from? They're taking too long.
I think they must be in room 4, Honorable Speaker. Our first witness is the Honorable Ekomas Mwengi Motuse, who was the mover of the motion.
Are you sure he's not deserted you?
It is always a risk in this type of business, Honorable Speaker, but I'm sure he's around.
So, Counsel, before you proceed, you first introduce yourself and the team.
Yes, for the record, Honorable Speaker, my name is Mudhomi Viankolu. I'll be doing the exam-in-chief on behalf of the National Assembly. I shall be assisted in that enterprise by my learned friend, Mr. Peter Manyonge Wanyama. I will cover grounds 1, 5, 6, and 7, and my learned friend will lead the witness in respect of the other grounds in the motion.
May the witness take the oath.
I, Mwengi Motuse, do solemnly swear that the evidence that I shall give before the Senate in respect of the matters before the Senate shall be the truth, the whole truth, and nothing but the truth. So help me God.
Your 3 hours starts running from now.
So, good afternoon, sir. Again, just for the record, confirm your name and what you do for a living.
Mr. Speaker, Honorable Senators, my name is Mwengi Motuse. I'm the Member of Parliament for Kibwezi West constituency, and I was the mover of the instant motion that is before your consideration in the National Assembly. I am also an advocate of the High Court of Kenya by profession.
So, great. Let's go straight to the motion due to the constraints of time. Honorable Speaker, the motion is in volume 1 of the Assembly's bundle of documents. And allegation number 1 runs from pages 3 to 10 of volume 1. So, without much ado, Honorable Motuse, let's go to allegation number 1 of your impeachment motion. Can you tell the Senate in very condensed summary what is the grievance you have raised against His Excellency the Deputy President?
Honorable Speaker, Honorable Senators, on our ground 1 allegation against the Deputy President is that he has violated various articles of the Constitution that we have listed, being Article 10(2)(a), 10.2b, Article and C, Article 27, Article 73.1a, Article 732b, 75.1c, Article 129, as well as Article 147.1 as read together with Article 131.2c and b. And basically, what we are saying is that the Deputy President in the last 2 years has been in various places within the Republic of Kenya and has been publicizing a notion that Kenya is a company that is owned by shareholders, and only those who have shares in the company called Kenya, according to him, will benefit in terms of development and service delivery from the Republic. And it is our contention that Kenya is not a company. Kenya is a republic that is supposed to serve all Kenyans. And the particular articles of the Constitution that we have cited because of time also speak to the functions of the Deputy President being able to promote national unity and the country, citizens of Kenya being able to receive services and development from the government, including appointments, without discrimination. So that is in short.
Let's quickly go through some of those provisions. If you could be shown the preamble to our Constitution, what does the third paragraph say?
Mr. Speaker, honorable senators, the preamble to our Constitution, and I read the third paragraph, proud of our ethnic, cultural, and religious diversity. Underline ethnic, cultural, and religious diversity, and determined to live in peace and unity as one indivisible sovereign nation. One indivisible sovereign nation.
We'll come to the evidence you have adduced to support this shortly, but are the utterances you complain about consistent with that constitutional provision?
Definitely not at all.
Let's go quickly to Article 10. What does it say?
Article 10.1.